But one habeas corpus matter I filed yesterday, can it come tomorrow for habeas corpus? I give.
କାଲି ନହେଲେ ସୋମବାର ଦିନ ଦେଖି ନେଇ ଆସିବ ଡିଫେକ୍ଟ ରିମୁଭ କରିଦେଇଛନ୍ତି ତ
habeas corpus let it come tomorrow.
ନାଇଁ ସେଗୁଡା କଣ ହେଇଛି ଡିଫେକ୍ଟ ନ ରିମୁଭ କଲେ ମୁଁ
solve it. Let it come on Friday or anyway Monday.
डायरी नंबर हो डिफेक्ट तांको इंटीमेशन जो डिफेक्ट रिमूव कले ही केस नंबर टा हो सेउटा
But that notification should, with all respect,
नहीं किछि कोंतुनी
no, for bail habeas corpus and injunction matter, that should come, should not wait that thing.
डी अछि माने डिफेक्ट अछि मु सेत नै कहली माने आपनकर डी मींस
no, I know the here there is no date, there is nothing synopsis. So that is why I have not given. But my clerk said that there is otherwise also that is to be given to remove the defect. So I have prepared. It is filed today.
It's all
it is filed.
It will go. Yes.
Because there is nothing to give date. So what is the date chart? So if there is nothing to give for synopsis, that synopsis I have given one paragraph, but just to avoid the defect.
Yes. Mr. Yes.
IPC and sentencing for life. There are two accused persons. One was convicted and another was acquitted. The prosecution case is that the appellant, while coming from the workplace, he has vomited in the house of in front of the house of the deceased man. Thereafter, there was a hot exchange of word, and the appellant only gave a blow by a stick man. Again. That is at page 18 man. May I permit you? More Swanso. Hirakudra Rice. Is a wife of the deceased.
One.
Swanso, Hirakudra Rice mill colon. Mailer. ହୀରାକୁଦ ରାଇସ୍ ମିଲ୍ କଲୋନୀରେ ଘରେ ରହୁଛି। ମୋର ସ୍ୱାମୀ ମୋ ସହିତ ରହି ଭଏସ୍ ଚରାଉଥିଲେ। ଗତ ତା ଏତିକି ରାତି 8 ବଜେ ମୁଁ ମିଲରୁ କାମକୁ ଆଇଲି। ବୁଢ଼ା ରାନ୍ଧି ସାରିଥିଲେ। ଦୁହେଁ ମିଶି ଖାଇଲୁ। ଖାଇଲା ବେଳେ ଆମ ପଡ଼ିଶା ଘରର ସମ୍ପଦ ପାତ୍ର ହି ଇଜ୍ ଦ ଆପିଲାଣ୍ଟ ମଦର ଘର ବାଟେ ଉଲ୍ଟି କଲା। ମୁଇଁ ଖାଇଲା ପରେ ଘରେ ବର୍ତ୍ତନ ମାଜୁଥିଲି। ମତେ ବୁଢା ପଚାରିଲେ ଘର ବାଟେ କିଏ ଉଲ୍ଟି କରିଛି। ମୁଇଁ ସମ୍ପଦ ଉଲ୍ଟି କରିଛି ବୋଲି କହିଲି। ସେତିକି ବେଳେ ସମ୍ପଦ ତାର ଘର ବାଟେ ବସିଥିଲା। ତାକୁ ବୁଢା ଇନେ କାହିଁକି ଉଲ୍ଟି କଲୁ କହିବାରୁ ସମ୍ପଦ ବୁଢାବୁଢୀ କହିଲା। ବୁଢା ତାକୁ ମନା କରିବାକୁ ସମ୍ପଦ ବୁଢାକେ ବାଡିରେ ଖୁବ୍ ପିଟିଲା। ମୁଇଁ ଛଡେଇବାକୁ ଯିବାରୁ ମତେ ପିଟିଲା। ସେତିକିବେଳେ ଆମ କଲୋନୀ ପଡାର ନକୁଳ ଛଳାଛଳି କରିଲା। ସମ୍ପଦ ବୁଢାଙ୍କୁ ସେନେ ହାପସି ଦେଲା। ତାପରେ ବୁଢା ତାକୁ ମନା କରିବାରୁ ସମ୍ପଦ ପିଟିଲା। ମୁଇଁ ଛଡାଇବାକୁ ଯିବାରୁ ମତେ ପିଟିଲା। ସେତିକିବେଳେ ଆମ କଲୋନୀ ପଡାର ନକୁଳ ଛଳାଛଳି କରିଲା। ସମ୍ପଦ ବୁଢାକୁ ସେନେ ବୁଢାକୁ ସେନେ ହାପସି ଦେଲା। ତାପରେ ବୁଢା ଉପରେ ଇଟା ଖଣ୍ଡ ଫିଙ୍ଗି ମାରିଲା। ଇଟା ବାଜି ବୁଢାର ଗୋଡ ଖଣ୍ଡିଆ ହୋଇଛି। ମୁଇଁ ବର୍ଷାରେ ଛକ ଆଡେ ଯାଇଥିଲି। ତୁ ବର୍ଷା ହେବାରୁ ଘରକୁ ଫେରି ଆସିଲି। ବୁଢା ତାପରେ ମତେ ପାଣି ଟିକେ ଦିଅ ବୋଇଲା। ମୁଇଁ ପାଣି ଦେଲି। ଟିକେ ପାଣି ପିଇଲା ପରେ ବୁଢା ଖରାପ ହୋଇଗଲା। ସେତେବେଳେ ରାତ୍ର 10ଟା ହେବ। ମୁଇଁ କନ୍ଦାକଟା କରିବାକୁ ରାତିରେ ପଡାରେ ଅନ୍ୟମାନେ ଉଠିଲେ। ସମସ୍ତେ କହିବାରୁ ମୁଁ ଥାନାକୁ ଆସି ରିପୋର୍ଟ ଦେଇଛି।
ପାଣି ପିଇଲା ପରେ ବୁଢା ଖରାପ ହୋଇଗଲା ମାନେ କଣ ତା ମରିଗଲା? ଆଚ୍ଛା, ମୁଁ କହିଲି ତା କଣ୍ଡିସନ କ୍ରିଟିକାଲ। ଆଚ୍ଛା, ଖରାପ ହେଲେ ସେତେବେଳକୁ ରାତି ପ୍ରାୟ 10ଟା ହେଲା। ମୁଇଁ କନ୍ଦାକଟା ରାତିରେ ଥିଲେ। ସମସ୍ତେ କହିବାରୁ ମୁଁ ଥାନାକୁ ଉଠେ ପିଟିଆର ମତେ ଖରାପ ହେଇଗଲା। ଓକେ, so the co-accused was acquitted and this appellant was convicted under section 302.
Now charge was 302 3 SC
302 and 3 SC Act.
No, 302 34.
So also no separate charge was framed under section 302 against this Sampath, right? Then how many eyewitnesses are there?
There are two eyewitnesses, the wife and the son. And PW1 2.
Eyewitnesses PW1
and 2.
PW2. And who is the doctor who conducted PM?
PW7.
PW7, doctor.
PM.
But from the FIR, it appears that PW1, the informant also sustained some injuries. No injury. No doctor.
No.
Okay. Then you come to the evidence of these two eyewitnesses first.
PW1.
Other eyewitnesses, but they have been not supported the prosecution case for which they have not declared hostile.
Okay. So first come to PW1.
And these two witnesses, they have also again examined. I know both the accused person in the dock The deceased Buddhiram Kirketa was my husband. On 14/9/2003, I was working in Hirakud rice mill. On that day, I returned home at 8 p.m. after my duty hours were over. After returning home, I served food to my children and thereafter myself and deceased took food. We are staying in a quarters inside the mill premises. While the deceased was taking his food, accused Sampada vomited near our house. The deceased protested against this. I also protested. At that stage, accused Sampada brought out a lathi to assault my husband. Accused Nakula asked him as to what had happened. Accused Nakula dragged the deceased and both the accused person then assaulted the deceased by means of lathi all over the body. I tried to intervene. The accused persons also assaulted me, my children. The deceased sustained serious injuries as a result of such assault. I went to remain shocked to call the police, but returned back as I did not find any police personnel. The deceased asked me for water, and after taking water, he expired. In the next morning, I went to the police station and verbally reported the matter to the police. The police reduced my verbal report to writing. It was read over and explained to me, and finding it to be correct, I put my thumb impression on the report reduced to writing by the police. The police came to the spot and had inquest over the dead body of my husband and prepared the inquest report. I put my thumb impression on the inquest report, so prepared at the spot. The deceased was assaulted by means of a bamboo lathi. Among one is that bamboo lathi which the deceased was assaulted by Sampath. Cross examination. I was examined by the police. It is not a fact that I have not disclosed in the FIR, in my FIR or in the statement before the police that accused Nakula dragged my husband and assaulted by means of lathi. It is also not a fact that I did not disclose it in my FIR or in my statement before the police as the accused Nakula, as the accused Sampada, as to what had happened. It was raining heavily at the time of occurrence. At the time of occurrence, big heap of stone were lying in the front of my quarters. Accused Sampada vomited near that heap of stones. The occurrence took place near that heap of stones. The quarters of Utsava Behera, TSPW 8 miler, Ganesha Vanchar, Krishna Lagoon were close to the quarters in
They have not been examined. Ganesha and Krishna have not been examined.
No. Khali PW8.
Okay.
He has not supported the prosecution case.
Okay.
I was staying quarters were close to the quarter in which I was staying. I cried out for help when the accused person assaulted my husband. Only Utsava came to the spot. The other neighbors did not come. They come only in the next morning. I narrated before Utsava that the accused Nakula dragged my husband and assaulted him. Other police officers were present when I lodged my oral report in the police station. During night of occurrence, when I had been to the police station, there was none available there. Remain Chowk is the crowded area which shops and other establishments. I narrated the incident to the police available in the Remain Chowk when I did not get any police officer. I cannot name those persons before whom I narrated the incident. It is not a fact that Nakula did not assault my husband at all. It is not a fact that the deceased fell down on the heap of stone, and so and sustained injuries. After accused Sampada vomited near my house, the deceased and Sampada abused each other in obscene language. There was no tussle between them. I cannot say as to how long the incident continued. The accused person left the spot after assaulting the deceased. It is not a fact that I did not state before the IO that I protested when the accused Sampada vomited near my house. It is not a fact that accused Sampath did not assault my husband and that my husband and Sampath quarreled with each other and there was physical tussle between them. And in course of that tussle, the deceased fell down on the heap of stone and sustained injuries.
So this is PW1. Now we'll come to PW2.
He is the son of the deceased. I know both the accused person in the dock. Deceased Buthiram Kerkatai was my father. About 2 to 3 years ago, around 9 to 9:30 p.m., accused Sampada came near the residence and started vomiting. My father protested. Thereafter, accused Sampada abused my father in filthy language. Both the accused persons dragged my father out of the house and assaulted him by means of lathi. My father was seriously injured and died. Myself and PW1 tried to intervene to save the deceased. We are also assaulted by the accused persons. My younger brother was also assaulted. I cannot identify the lathi.
I can.
I can identify the lathi with my father was assaulted. This is the lathi M1 by means of which Sampada assaulted me.
PW2 भी पहुंची, PW1 पहुंची, that the accused persons also assaulted me and my children.
My lord.
To that effect, there is no medical evidence.
No medical evidence.
Okay, continue.
My lord. I was examined by the police in this case. It is not a fact that I did not state before the police that accused Nakura dragged the deceased and assaulted by lathi. I myself, my mother, Pidolwan and younger brother also sustained injuries while trying to protect the deceased. I showed my injury to Ayo. At that time, at the time of assault, I and Pidolwan raised alarm, as a result of which the neighbors, Uchava, Ganesha, Krishna, Punya, Nath arrived at the spot. I disclosed.
PW8 is our examining.
Again.
Yes.
I disclosed before them that the accused persons had assaulted the deceased and they had also assaulted me, my brother and mother. Me and my brother and mother. After accused Sampada abused my father, the latter returned the abuses. It is not a fact that there was a tussle between my father and the accused Sampada, and in the process, my father fell down in the heap of stone and sustained injury. It is not a fact that Nakula did not at all assault the deceased. It is a fact that there was a physical tussle. It is not a fact that there was a physical tussle between the deceased and the accused Sampada, and the process, the deceased fell down on the heap of stone and sustained injuries. My lord, PW1 and 2, they have examined.
Examined as a PW3.
Again?
Ganesh has been examined as PW3.
Oh, Ganesh Bansal.
Inquest.
Not inquest, eyewitness.
Not stated as an eyewitness. So he stated that when we shouted, the Ganesh reached at the spot, but he has not stated to be an eyewitness to the occurrence.
No.
Now, your lordship will kindly see PW1 and 2, they have examined on 3rd March 2006.
March 2006,
my lord. My lord, before that, they have been examined page 59, my lord.
59.
My lord. On 10th November 2004, they have first examined.
No, the charge which was framed.
Again. Charge.
That was the first charge was framed on 31/8/2004.
Again.
That was only against Sampath.
Again.
So maybe that thereafter an application was filed under section 319 CRPC. After the evidence was adduced, and then the
Sampada have been added as
then again it was the charge was reframed, and again the of course the after once the evidence is recorded, the power is with the trial court either to start it de novo, or he can start it, give an opportunity to the newly added accused for cross examination. 319, if we come, power to proceed against other persons appearing to be guilty of the offense. Where in course of inquiry into or trial of an offense, it appears from the evidence that any person not being the accused has committed any offense. Here initially only accused who was facing trial is Sampath Patra.
Mild.
So then evidence was recorded, this both the eyewitnesses, then it appeared perhaps that the other accused has, because they have implicated that both of them assaulted. So for which such person could be tried together, the court may proceed against such person for the offense which he appears to have committed. When such person is not attending the court, he may be arrested and summoned as the circumstance of the case may require for the purpose so and so. Any person attending in court, although not under arrest or upon a summons, may be detained by such court for the purpose of inquiry or trial of the offense which he appears to have committed. When the court proceeds against any person under subsection 1, that means the newly added, then the proceeding in respect of such person shall be commenced afresh and the witnesses be reheard. That is why it has been done. Subject to provision of section A, the case may proceed as if such person had been accused when the court took cognizance of the offense upon which the inquiry or trial commenced. So if the court adopts the second one, that is whatever evidence has already been recorded, if he wants to proceed, then charge would be framed against the newly added accused, and then he will be given opportunity to cross-examine the witnesses, right? And of course, the one line is to be recorded in the chief examination that this is that. Then because he will not claim prejudice. Otherwise, the proceeding is to be reheard. That means again those witnesses should come. That is what happened in this case. So they were
only thing, my lord, I am showing to your lordship.
Yes.
That
actually in this case what has happened that we want to see, because this is the general thing. So we want to see the order sheet of the London trial court. So let us see that these two witnesses were initially examined, PW1 and PW2, on
2004.
On 10th November 2014. So let us come to 10th November 2014.
14, not 4.
4.
2000. So 10th November. So there it is mentioned that accused present, accused was produced from Circle Jail. On the PP and that so and so gala. Two witnesses hajira dele, files hajira of two witnesses. Trial commenced, PW1 so and so is examined, cross-examined and discharged. PW2 Madhav so and so is at about 13 years. His competency was tested by putting questions to him. The witness is examined, cross-examined and discharged. At this stage, the PP files a petition under section 319 CRPC praying to proceed against Nakula Rana, son of so and so, for commission of offense under section so and so. Copy not sought, put up on such and such date. By so eta ko direction ala copy solve kuriya pai. So then the copy was solved. Okay, then the copy was solved. Then objection ପାଇଁ time ଦିଆଗଲା। ତାପରେ ବଢିଲା ପିଟିସନ ହିୟରିଂ ପାଇଁ। Then the order was passed on 3/12/2004. The accused is produced from so-and-so PP. So-and-so PP has filed a petition under section 319 CRPC praying to proceed against Nakula Rona, son of so-and-so. It appears in the case record, then it was discussed, then 319 provision discussed. Ultimately, it was allowed, hence the petition filed by the PP is allowed, issue NBW against Nakula Rona, so-and-so, and accordingly, he added he faced the trial, okay? So, the order passed incomplete, who accused. Nakula Rona. That petition was filed on 10/11/2004 after examination of PW1 and PW2. Well said.
My lord, only
Yes.
thing I will place before lordship, the evidence which they have adduced on 10th November 2004, it is, my lord, in relation to, my lord, the appellant, my lord.
No, no.
That cannot be totally washed out. The evidence.
No. Suppose they have stated against both the appellants. This appellant, so also the co-accused. That is the reason why 319 petition was filed.
Yes, my lord.
And the court was convinced that there is some prima facie case against the co-accused and accordingly added. Yes.
Again. But, my lord, in the examination on 10th November 2004,
yes,
they have stated a different story than, my lord, after they have examined again.
In that event, it is required to put questions by way in the cross-examination that on such and such date you have been examined. That is the fundamental thing. Unless you do it, how can we utilize it? Because that evidence is there and it is to be brought to the notice that 10/11/2004 रे तमे एई कोर्ट रे आसी एक नंबर साक्षी हिसाब रे एग्जामिन हेलो एवं सेतेबेले एई कथाटी कहिथिलो ताकू अपॉर्चुनिटी देई थांते. So any previous statement reduced to writing is to be confronted in accordance with section 145 of the evidence, then can only the court take into account. ତେଣୁ ସେଠି ଗୋଟେ କଥା କହିଲେ 161 ରେ କଣ କହିଲେ 164 ରେ କଣ କହିଲେ, that is to be brought on record by legal means. So that has not been done. We find that at least so then now comes
doctor evidence.
Now comes to doctor evidence.
PW7.
At page 44, man.
Just a minute.
Man. On 15/8/2003, I was working as assistant professor, so-and-so VSS Medical College Hospital, Bulla. On that day at 4 p.m., on police requisition, I conducted autopsy on the dead body of one Buddhiram Karketa of village so-and-so, this is so-and-so. The dead body being identified the constable Ramani Ranjan Mishra. I found the following external injuries: parallel bruise of so-and-so CM present on the left side of the back on 11th and 12th ribs. Contusion of size epigastric region. Lacerated wound on right, এটা কোন লেখা আছে?
ফুট রে আছে।
ଆଜ୍ଞା
तीन या चारिटा होची गोटे अछि फुट रे अछि आ गोटे से बाम पट टो रे अछि so
ଆଜ୍ଞା
these are
ସେଇଟା
not so on dissection you
on
found
dissection I found following back chest and contused on the left side on the area just below the injury number 1. The abdominal wall was contused on
spleen rupture jogu ye
मरिगला
death heichi. So because that blow was given on the chest and that 11th and 12th rib जगह parallel bruise अछि ए तोला आड़कू then
affect the liver.
So that was in the kidney was contused that obviously.
And doctor has also in the cross examination said injury number 1 can be caused by one heavy lateral blow.
It was due to shock and hemorrhage arising due to rupture of liver and spleen. Injuries are sufficient to cause death under ordinary course of nature, so and so. Lathi has 7 knots. He has also examined that lathi and given his opinion that it has 7 knots. Bricks was broken, so and so. I examined the lathi and the brick. Okay, this is possible by, so that is external injury. Now the statement of this both the witnesses that the lathi blow was given is getting corroboration from the evidence of the medical evidence. Other witnesses are not very material.
Nah.
Okay, the London trial court acquitted the co-accused mainly on the ground that it was stated for the first time in court. Please show that line. Where the evidence against the co-accused has been.
My lord, your lordship will kindly turn to page 11, my lord.
No, it's all right, but discussion
12,
paragraph 7, you come to that. Paragraph 7, page 9.
Again, in view of the evidence discussed above, it will be convenient to discuss the evidence appearing against the accused Nakula. Again, in the FIR, the informant has not implicated accused Nakula as one of the assailant. She has stated in the court that accused Nakula dragged the deceased and both the accused persons assaulted the deceased by means of lathis. She has not stated so in her statement before the IO, recorded under section 161 CRPC. The IO was confronted with the statement of PW1. The IO has stated that PW1 did not state before him that the accused Nakula dragged the deceased and assaulted him by means of lathi. Similarly, PW2 has not stated before the IO that the accused Nakula dragged the deceased and assaulted him by lathi. For the first time in the court, they have implicated the accused Nakula, and as such, the accused Nakula was implicated as an accused during trial. In view of the fact that PW1 and 2 have not implicated accused Nakula in their earliest statement before the IO, they are evidence that the accused Nakula dragged the deceased and assaulted him with lathi cannot be believed. There is no other evidence appearing against the accused Nakula to implicate him in this case, so he is entitled to get acquittal, clean acquittal.
So, how do you challenge now the evidence of this two eyewitnesses and the medical evidence when the person who has been implicated during the trial for the first time, he has been acquitted because nothing was stated against him either during in the FIR or against, but so far as this appellant's overtact is concerned, that is there in the FIR, that is there in the 161 statement, the witnesses have also stated. In addition to that, the medical evidence also corroborates the evidence of the witnesses. So far as those materials are concerned, how do you say that the conviction is not sustainable?
My lord, I want to submit, my lord. These are the evidences which are against the accused, my lord. And I have not, my lord, brought out any evidence to dislodge their evidence. But only thing I will pray before your lordship, that the incident took place out of, my lord, it is not premeditation, out of, my lord, a quarrel, that incident took place, and the weapon of offense is also not a, my lord,
weapon of offense was verified.
Lathi. And he has, well, one only thing, my lord, the injury is one, fatal injury is one.
Background dispute is there, sudden dispute, sudden quarrel ensued because of that vomiting. Okay. Then it was challenged and this occurrence took place.
And he has given one blow, my lord.
But no, one blow.
In the other injuries, my lord, the doctor has opined that might be, my lord, after he fell down in the heap of stone.
Where is that?
That is, my lord, your lordship, in cross-examination, your lordship will kindly see. Page 47.
Except parallel injury, the other injuries could be on the
caused by on one fall.
So, Mr. Tripathi, yes, now the principle laid down by the Supreme Court, which is consistently followed, that the witnesses can be categorized into three types. One is the witnesses who are fully reliable, then the witnesses who are wholly unreliable, and the witnesses who are neither wholly reliable nor wholly unreliable. So it says that if it is wholly reliable, then statement of even one witness is sufficient and no corroboration even if it is necessary. If it is wholly unreliable, then the evidence has to be discarded. But when the evidence is neither wholly reliable nor wholly unreliable, then the duty of the court is to assess the evidence and seek for independent corroboration. Okay, that corroboration may be received from the other witnesses' evidence or medical evidence or background of the case, whatever it may be. So, whatever evidence has been adduced by this PW1 and PW2,
that is corroborated by the doctor.
No, first, which category according to you they would come? Because a person's name, which they have not stated in the FIR, which they have not stated in the 161 statement, they are for the first time introducing that person in a case of murder. So can they be said to be a wholly reliable?
No.
Because that part of their evidence has been discarded. So they would, according to you, if they would come within the category of neither wholly reliable nor wholly unreliable, then the rule of prudence is that it is to be, the court has to look into corroboration. Then the corroboration in this case is only comes from this medical evidence, right?
Yes.
So medical evidence, though indicates that there are as many as 4 external injuries, it indicates that only one injury which has proved fatal because it has caused the hemorrhage and rupture of the liver and spleen, which has been opined, of course, to be sufficient to cause death. But the no, this except the parallel injury. Parallel injury means injury number 1. The other injuries could found on the dead body could be caused by fall. Then he says injury number 1 can be caused by one heavy lathi blow, except injury so and so 3 and 4 be for why as এবং তারপর পুଣି clarify করছি 2, 3, 4 could also be simultaneously caused by one flow. So এই ତେଣୁ ଏଇ ଯୋଉ ତିନିଟା ଇଞ୍ଜୁରି ଅଛି 2, 3, 4 ଯଦି ଫଲ୍ ଯୋଗୁ ହୁଏ ତେଣୁ ଗୋଟେ ବ୍ଲୋ ଏବଂ ଆପଣଙ୍କର କେସ୍ ବି ନୁହେଁ ସେ 1 ନମ୍ବର 2 ନମ୍ବର ଯେ କୌଣସି ଆକ୍ୟୁଜ ମେ ବି ଦି ଖାଲି ଜଷ୍ଟ ପ୍ଲେନଲି କହିଛନ୍ତି ଏମାନେ ରିପିଟେଡ ବ୍ଲୋ ଦେଇ ଚାଲିଲେ ବୋଲି କିଛି କହିନାହାନ୍ତି ତେଣୁ ଏଇ ବ୍ୟାକଗ୍ରାଉଣ୍ଡକୁ ଆମେ ଯଦି ରଖିବା ଏଗୁଡାକ କିଛି ଏଭିଡେନ୍ସ ନାହିଁ that there was any previous dispute between the parties. So no previous dispute and the occurrence happened all on a sudden.
After vomiting that.
Right. Again you come to that portion, the deceased was taking food, so ସେ ତା ଘର ପାଖରେ ଆସି ସେଇ ସମୟରେ ବାନ୍ତି କଲା. The deceased protested and he protested. ତାରି ପରେ ଘଟଣାଟା ହେଇଛି ତେଣୁ all on a sudden single blow has been given, and it has that single blow has caused rupture of the spleen and so on. So it would be a case under section 304 part 2, not 302. And what sentence you have already undergone?
My lord, I have already undergone 7 years.
Can you tell me that when you were
Again. My lord, the appellant was arrested on 16/8/2003, my lord.
Let us see that final form. Shampad. He was taken into custody 17/8/2003 was forwarded.
My lord.
And he was not on bail.
No. Thereafter, he was released on bail by this honorable court.
So accused persons produced. Person so and so produced. ନକୁଳକୁ ବେଲ୍ ହେଇଗଲା
ଆଜ୍ଞା
ନକୁଳ ବେଲ୍ ପାଇଗଲା ମାନେ ତାପରେ he was bailed out then but this man ନକୁଳ was present ତାର ତରଫରୁ ଇଏ ଚାଲିଛି ସମ୍ପଦ introduced I mean he is in custody. Okay. Nokula is present, Sampath produced.
ବବି ତ ଯାଇଛି
Right. So judgment pronounce ହେଲା ପର୍ଯ୍ୟନ୍ତ ଅଛି ତ ଏଠୁ ବେଲ୍ ଗଲା କେବେ
15/7/2011
15/7/2011 ତାମାନେ ଏଟା ହେଉଛି ଆପଣଙ୍କର
7 years 11 months
7 years 11 months, right? डिसीजन आनिछन से जो सिंगल ब्लो लाठी रे स्प्लीन फ्रैक्चर ऑब्जर्व करिवो ऐसे डिसीजन बाहर कर दो सिंगल ब्लो चेस्ट rupture of liver and spleen 304 part 2 board decision अछि take down JCRLA number 67 of that 2008 the appellant Sampath Patra.
Your Lordship, my lord, kindly grant me leave, my lord.
Yes. The face trial in the court of London Session Judge Sambalpur along with co-accused Nokkulo Rona for commission of offence punishable under section 302 Redui section 34 of the Indian Penal Code on the accusation that on 14/8/2003 at about 8 p.m. at Hirakud Rice Mill Colony, in furtherance of their common intention, they committed murder of Buddhadev Kerketa, bracketer hereafter the deceased. Though the London trial court acquitted the co-accused Nakula Rana, but found the appellant guilty under section 302 of the Indian Penal Code. (302/34 (302/34 of the Indian Penal Code) and sentence him to undergo imprisonment for life. The prosecution case, as per the first information report, lost by Srimati Miriam Kerketa, bracket PW1, the widow of the deceased, on 15/8/2003 before the officer in charge of Ointapoli police station in short is that the informant and the deceased were staying in the Hirakud Rice Mill Colony and they were tending bullocks on 14/8/2003 in the night at about 8 p.m. The informant, bracket PW1, returned from his work in the mill, and by that time the deceased had already cooked food. Both the appellant and the deceased, both the deceased and the PW1 took their dinner. While they were taking their dinner, the appellant, who was staying in the neighborhood, started vomiting in front of the house of the appellant. in front of the house of the in front of the house of the deceased. The PW1 was cleaning her utensils after the dinner. The deceased asked PW1 as to who had vomited in front of their house. In reply, PW1 stated that it was the appellant, Shampat Patro. At that point of time, the appellant was sitting in front of his house. The deceased confronted him as to why he had vomited, to which the appellant told, old man, inverted comma. When the deceased asked the appellant not to say so, comma, the appellant assaulted the deceased by means of a lathi. PW1 tried to intervene, but she was also assaulted by the appellant. At that point of time, the co-accused Nakula arrived at the spot and tried to separate them, and then he threw a brickbat on the deceased, for which the deceased sustained injury on his legs. PW1 left the scene of the occurrence and proceeded towards Chuck. But since it was raining heavily, she returned home, and at that point of time, the deceased asked her to provide some water. And accordingly, PW1 gave him water. After taking some water, the deceased died at about 10 o'clock in the night. When PW1 cried, the other persons in the locality came, and they asked the PW1 to report the matter in the police station. And accordingly, the report was lost. PW1 gave the oral report before PW11 Suresh Kumar Das, the officer in charge of Ointapalli police station, on 15/8/2003 at about 3 a.m., which was reduced into writing by PW1, and it was read over and explained to PW1. And after she admitted the same to be correct, her thumb impression was taken on such report, which was treated as first information report, and accordingly Ointapalli PS case number 168 dated 15/8/2003 was registered under section 302 of the Indian Penal Code against the appellant. PW11 himself took up investigation of the case. During course of investigation, he examined the informant bracket PW1 and other witnesses, visited the spot, seized bamboo lathi and some broken pieces of brick and half set of the appellant under seizure list Exhibit 6. The bamboo lathi which was lying at the spot was the inquest over the dead body was held in presence of the witnesses. An inquest report Exhibit 7 was prepared, and then the dead body was dispatched to BHS Medical College and Hospital, Burla, for post-mortem examination, being escorted by the constables. After post-mortem examination, the wearing apparel of the deceased were produced before the IO, which were seized as per seizure list Exhibit 1. The appellant was arrested on 16/8/2003, and he was forwarded to court on 17/8/2003. On 1/9/2003, the IO bracket PW11 made a query to the doctor who conducted post-mortem examination to ascertain if the death of the deceased could be caused by bamboo lathi bracket MO1 and broken piece of brick bracket MO3. And on 16/10/2003, he received the post-mortem examination report, so also the answer to his query. On 16/10/2003 itself, PW11 handed over the charge of investigation to Circle Inspector of Police, Sadar, Sambalpur. Bracketary PW9. Who wrote a letter to RI Sambalpur to demarcate the spot after measurement and obtain the report from the RI. And on completion of investigation, PW9 this is LCR. No, this is a paper book, LCR trial court report. That's true. Submitted charge sheet only against the appellant Sampath Patra under Section 302 of the Indian Penal Code on 15/11/2003. The case of the appellant was committed to the Court of Session, and on 31/8/2004, charge was framed under Section 302 of the Indian Penal Code against the appellant, which he pleaded not guilty and claimed to be tried. And accordingly, the informant was examined as PW1, and her son was examined as PW2, and both these witnesses were also cross-examined and discharged. On 10th November 2004, after examination of these two witnesses, on the very day, the London public prosecutor filed a petition under Section 319 CRPC for adding the co-accused Nakula Rana to face trial along with the appellant. And on 3/12/2004, the petition filed by the public prosecutor was allowed, and the co-accused Nakula Rana was arraigned as an accused, and he faced trial along with the appellant, and charge was framed against both the appellants on 2/12/2005 under Section 302, read with Section 34 of the Indian Penal Code, to which both of them pleaded not guilty and claimed to be tried. During course of trial, the prosecution examined as many as 11 witnesses, put them then. The prosecution also exhibited 8 documents, give it. The prosecution also proved 4 material objects, give it. The defense plea of the appellant is one of denial, and it is further pleaded that there was a quarrel between the deceased and the appellant, including physical tussle, and in course of such tussle, the deceased fell down on the heap of stones and sustained injuries. And that a false case has been foisted against him. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that since PW1 and PW2, the two eyewitnesses, have not implicated the co-accused Nakula Rana in their earliest statement before the IO, their evidence that the said co-accused dragged the deceased, assaulted him with lathi, cannot be believed. And since the Lenin trial court found no other evidence appearing against the co-accused Nakula to implicate him in the case, he was acquitted of the charge. The Lenin trial court, however, on the basis of the eyewitnesses' account of PW1 and PW2, held that their evidence is consistent regarding the assault by the appellant, and that the defense plea that there was tussle between the deceased and the appellant, and the deceased fell down on a heap of stones and sustained injuries, cannot be believed at all. The Lenin trial court also took into account the post-mortem report finding and came to the conclusion that the death of the deceased was due to assault by the appellant by means of a lathi, which caused internal injury like rupture of liver and spleen. Accordingly, held him guilty under Section 302 of the Indian Penal Code. Ms. Dipali Mahapatra, Land Counsel appearing for the appellant, contended that since the two eyewitnesses, that is PW1 and PW2, have not stated anything against the co-accused Nakula Rana in their previous statements recorded by police and implicated them for the first time during trial, and the Lenin trial court has disbelieved their evidence so far as the implication of the co-accused Nakula Rana is concerned, they cannot be said to be absolutely reliable witness. The Land Council submits that it has come on record that there was big heaps of stones lying in front of the quarters of the deceased, and it has further come on record that the deceased fell down, and therefore and the doctor has also stated that the some of the injuries sustained by the deceased, except one injury, all other injuries sustained by the deceased were possible on account of fall. And therefore, the evidence of these two eyewitnesses are not sufficient to hold the appellant guilty under Section 302 of the Indian Penal Code. It was further argued that from the postmortem report, it appears that one blow was given on the left side back on 11th and 12th rib, on account of which there was rupture of liver and spleen. And since there was no previous enmity between the appellant and the deceased, and all on a sudden the occurrence took place as the appellant vomited in front of the house of the deceased while the latter was taking food, to which the deceased objected, in such a scenario, the case would fall within the exception 4 to Section 300 of the Indian Penal Code, and it may be a case under Section 304 Part 2 of the Indian Penal Code. She further argued that the appellant was taken into judicial custody on 17/8/2003, and during trial he was never released on bail, and after filing of this appeal he was granted bail on 15 as per order dated 15/7/2011, and as such he has remained in custody for 7 years and 11 months. And since the occurrence in question took place in the year 2003, and more than 20 years have already passed, and the appellant is enjoying liberty for more than 12 years, even if this court held the appellant guilty under Section 304 Part 2 of the Indian Penal Code, the sentence be reduced to period already undergone. Put a line upper लिख देवे. The Learned Council submitted that even though the entire case of the prosecution is raised mainly on the evidence of the two eyewitnesses, PW1 and PW2, but their evidence which was given for the second time, that is on 3rd March 2006, when he faced trial along with the co-accused Nakula Rana, is contradictory to their evidence which they had given while the appellant was alone facing trial, but they given on 10th November 2004 while the appellant was given facing trial alone. Mr. Tripathi Lanan, Additional Standing Counsel, on the other hand, supported the impugned judgment and argued that the Lanan trial court has separated the grain from the chaff And since the co-accused Nakula Rana was implicated for the first time during evidence of PW1 and PW2, and there was no previous statement of those two witnesses implicating him. Before police, the London Trial Court has rightly acquitted the said co-accused Nakula Rana. However, the evidence of these two eyewitnesses is consistent so far as the implication of the appellant is concerned. And the assault made by the appellant is getting corroboration from the medical evidence which was adduced by the doctor PW7, who has stated that there was a parallel bruise on the left side back on 11th and 12th rib, and the death was on account of shock and hemorrhage, on account of rupture of the liver and spleen, and the injury are sufficient to cause death in ordinary course of nature. The London Trial Court has also took into account the fact that the doctor examined the lathi seized from the spot and gave his opinion that injury on the deceased were possible by such lathi, and the manner in which the assault has been caused, the part of the body where on which the uh, assault was made, and the impact of the assault on the deceased is brings it within the purview of section 302 of the Indian Penal Code, and therefore the appeal should be dismissed. Adverting to the contention raised by the learned counsel for the respective parties, let us first analyze the evidence on record as to how far the prosecution has established that the deceased met with a homicidal death. Apart from the inquest report, it appears that PW7, who was the assistant professor of FMT, BSS Medical College Hospital, conducted postmortem examination on 15/8/2003, and he noticed the following external injuries, quoted. And on dissection, he noted the following injuries. He opined paragraph 4 quote kariye. He also examined the bamboo lathi and the brick which was sent to him by the IO for examination and gave his opinion like this. The reports have been marked as so and so. In view of the London counsel for the appellant has also not challenged the homicidal death of the deceased. In view of the available material on record, particularly the inquest report, the postmortem report, the evidence of the Dr. PW7, we are of the view that the London Trial Court has rightly came to the conclusion that the deceased had met a homicidal death. Coming to the evidence of the two eyewitnesses to the occurrence, that is PW1 and PW2, there is no dispute that PW1 is the widow of the deceased and PW2 is the son of the deceased and they are related to the deceased, but relationship cannot be a ground to discard the evidence of such witnesses, inasmuch as related witnesses are not false witnesses and they are not likely to spare the real culprit and implicate someone falsely. The PW1's so the evidence of PW1 and PW2 has no doubt been disbelieved in part so far as their implication of the appellant, so far as their implication of a co-accused Nokula Rana is concerned. But law is well settled that the witnesses are generally categorized into three types, that is, witnesses who are fully reliable, witnesses who are wholly unreliable, and witnesses who are neither wholly reliable nor wholly unreliable. As far as the first category is concerned, while appreciating their evidence, the court faces no difficulties. Once a witness is accepted as wholly reliable, then such statement oblique evidence of a solitary witness can form basis of a conviction. Secondly, a witness who is wholly unreliable, entire evidence can be discarded. But in case of witness who is neither wholly reliable nor wholly unreliable, it is the duty of the court to assess the evidence and separate the chaff from the grain. And if the acceptance portion of the evidence is enough, it will not be illegal to convict the accused on the basis of such evidence. But normally, as a rule of prudence, the court, while appreciating a witness, who is neither wholly reliable nor wholly unreliable, it is better to look into other attending circumstances and corroboration before proceeding to convict the accused. In our humble view, both the witnesses PW1 and PW2 comes within the third category inasmuch as their implication so far as the co-accused Nokula Rana is concerned has been disbelieved by the London trial court. PW1 has stated that on 14/8/2003, he returned home at about 8 p.m. after working in Hirakud rice mill, and she served food to her children, and thereafter she herself and the deceased took food. She further stated that while the deceased was taking food, the appellant Sampath vomited near their house, to which the deceased protested, and PW1 also protested. At this, the appellant brought out a lathi to assault the deceased. The co-accused Nokula dragged the deceased, and then both the accused assaulted the deceased by means of lathis all over his body. She further stated that the accused persons also assaulted her and her children. And the deceased sustained serious injury as a result of such assault. And she went towards Ria Remad Chowk to call the police, but returned back as she did not find any police personnel. And then the deceased asked her to provide some water, and after taking water, he expired. She is not only the informant but also identified the bamboo lathi bracketry MO1 to be the weapon with which the appellant assaulted the deceased. By confronting the narration made in the first information report, so also her previous statement, the London Defense Council has proved the contradictions that she is implicating the co-accused. She was implicating the co-accused Nakula Rana for the first time in court as an assailant of the deceased. In the cross-examination, PW1 has stated that at the time of occurrence, big heaps of stones were lying in front of her quarters, and the occurrence took place near that heap of stone. She further stated that after the appellant vomited near her house, the deceased and the appellant abused each other in obscene language. PW2 has also stated about the assault on the deceased by both the appellants. And like PW1, the contradictions have been proved by the London Defense Council by confronting his previous statement regarding non-implication of co-accused Nakula in the previous statement and proving the same Nakula Rana to the investigating officer. Though PW1 and PW2 have stated that during course of occurrence, they were also assaulted, but no medical evidence has been adduced in that respect. No charge has also been framed in that respect. Therefore, the evidence of these two witnesses that the accused persons also assaulted them is not acceptable. Though the London Council for the appellant contended that the evidence given by PW1 and PW2 earlier, while the appellant was alone facing trial, is contradictory to the evidence adduced by both of them when the appellant faced trial along with the co-accused. But strangely, no such contradictions have been proved in accordance with law. If there is any contradictions between the two statements in view of Section 145 of the Evidence Act, it was the duty of the Learned Defense Counsel to bring the same to the attention of both these witnesses so that they would have got the chance to explain it away. Since the said procedure has not been adopted, we are not inclined to peruse the earlier statement recorded of these two witnesses being examined as PW1 and PW2 while the appellant was alone facing trial, and to verify whether there is any contradiction at all or not. It appears that there was no previous enmity between the appellant and the deceased, who are neighbors, and the occurrence took place all on a sudden when the appellant vomited in front of the house of the deceased while he was taking food along with PW1. And the evidence has come on record that not only the deceased protested to the appellant, but thereafter they abused each other. And though it is stated that lathi blows were given, but we find from the medical evidence that injury number 1 is possible by lathi, and except such injury, the other injuries are possible due to fall. And it appears from the evidence on record that there was a heap of stones in front of the quarters of the deceased, and the occurrence also took place near the heap of stones, and the appellant and the deceased fell down after lathi blow was given. Therefore, the contention of the Learned Counsel for the appellant that only one blow has been given by the appellant is acceptable. In the background of the case, when there was no premeditation and the occurrence happened all on a sudden. And during quarrel, the appellant has given only one blow, that too on the left side back of the deceased on the 11th and 12th reach, which unfortunately caused rupture of liver and spleen. We are of the view that the case of the appellant squarely falls within exception 4 to section 300 of the Indian Penal Code. And therefore, the London Trial Court was not justified in convicting the appellant under section 302 of the Indian Penal Code. The case should come within the purview of section 304 part 2, and accordingly the conviction is altered from section 302 IPC TO2 304 part 2 of the Indian Penal Code. It further appears that the appellant was taken into judicial custody on 17/8/2003, and during trial he was never released on bail. After filing of this appeal, he was granted bail on 15/7/2011, and thus he has remained in judicial custody for 7 years and 11 months. And more than 20 years have passed in the meantime, and the accused appellant has enjoyed the liberty for more than 12 years. In such a scenario, we are of the view that while convicting the appellant under section 304 part 2 of the Indian Penal Code, is sentenced to period already undergone. Accordingly, JCRLA is partly allowed. Put a note of appreciation on Ms. Mahapatra as well as Mr. Tripathi. Put a line kali lekhe debe. When the charge was framed under section 302/34 of the Indian Penal Code against the appellant, so also against the co-accused, and the London Trial Court has acquitted the co-accused, Nokudorona, he should not have convicted the appellant under section 302/34 of the Indian Penal Code. It good to line the bhitar pure do. Yes. Yes, next one.
Well, item 2932 re-engagement 36 29
Rajesh Panda.
Raja Chittaranjan Sahu, brief has been transferred to Koyar.
Nahi. So Chandana Panda is also C Panda. So somebody else has to be engaged.
Engaged, madam.
So
if out of
none appears for the appellant. Since it's a jail criminal appeal of the year 2005, we engage Ms. Anima Dey at the amicus curiae for the appellant. Let a copy of the paper book be handed over to her during course of the day. I don't signature nahi. Yes.
Another matter 32.
Yes.
That also to be engaged matter. No.
एटा गोटे कोन गोटे लेटर आसी टिके देखिले flag X लिखा है in obedience to and so I beg to submit that the copy of acknowledgement received also and so I verified the appellant residing along with his family members so and he stated that he will appear. आगुर नोटिस जाइतला कहला म appear करी बेली आउ किछि धरा छान देलानी. All right, as a note पड़े as a list was. So same order कर दियंतु कि engage ever phone.
Suman Modi.
Suman Modi is engaged at the amicus curie. This is item number 32 na?
Matter.
Okay. Okay, Chandikon.
Then my lord 36.
The name of the other council shall not be reflected in the cause list. Kar de. Hala? 36 kondu.
36 Ramanikanda Patnaik ଅଛନ୍ତି ସେଇଟା ବି କଟିବ.
କିଏ କୁହନ୍ତୁ କାହାକୁ engage?
List ରୁ ଦବା ନା ବାହାରକୁ? ଅନ୍ୟ list
नहीं जी ଅଛନ୍ତି କହିବେ 10 years practice ହେଇଥିବା ଦରକାର
criminal ସମ୍ବିତ ମହାନ୍ତି.
ହଁ ଠିକ ଅଛି
ସମ୍ବିତ ମହାନ୍ତି.
36 लिख दियंतु same order करिवे संबित महांती paper book handed over name only be declared. Yes, next
ବର୍ତ୍ତମାନ में
ଏତିକି ଥାଉ ଆଚ୍ଛା बाकी ଆଉ କିଛି matter ଅଛନ୍ତି କି
ନାଇଁ ଆଜି ମାନେ କାଲି ପାଇଁ ତ ଅଛି
କାଲି ପାଇଁ ଇଏ କରିଦେବେ ଇଏ ମାନେ କୁଆଡେ
କାଲି ଆଇଟମ 28
କ୍ରିମିନାଲ ଅପିଲ ଯୋଉଡାକ ଅଛି ସବୁ ବେଲ ଅଛି ଆମେ କହିଦେଇଛନ୍ତି ସବୁ ଗୁଡାକ ରିକଲ କରିଦେବି କରିଦବା ସବୁ ଆସି ଭିତରେ ପଶି ଯାଆନ୍ତୁ ଓକିଲ ବାବୁ ମାନଙ୍କ ପାଖରେ ଆସି ପହଞ୍ଚିବେ ତାପରେ ସବୁ ଯେତିକି ଅଛି ସବୁ ରିକଲ କରିଦବା ସବୁ ଆସି ଭିତରେ ବର୍ତ୍ତମାନ ଏନ୍ଜୟ କରୁଛନ୍ତି ଫ୍ରିଡମ ତ ତେଣୁ ତାଙ୍କର ବି ଚିନ୍ତା ନାହିଁ
Kunti Dipopani is there. Conduct tomorrow. ସେ କାଲି କରିବାକୁ କହିଛ.
Okay, ଛାଡି ଦିଅନ୍ତୁ ତାପରେ
29 engage ହେଲେ
29 engage then
30 ରେ ବି
item 30
30 କଣ ହେଲା
ମୁଳିଆ ବି ଆସିଥିଲେ just
ଆଚ୍ଛା ଠିକ ଅଛି ତୁମର କହିଦେଇକି ଆଉ ସକାଳୁ ନଥିବେ ଆମେ ଏଠି ଅଧଘଣ୍ଟା ବସିବୁ ହଁ ଲାଇଟ୍ କୁ ଅନେଇବୁ ଉପରକୁ ଅନେଇବୁ ସେ ଜିନିଷ ନ ହୁଏ. Yes, next
item 31
my lord, kindly taken on behalf of Rehana Khatun next week.
କଣ ପାଇଁ
ତାଙ୍କର କଣ ପ୍ରୋବ୍ଲେମ ଅଛି ନେକ୍ସଟ ୱିକ୍ କରିବା ପାଇଁ ମତେ କହିଥିଲେ.
ଯୋଉ ଲୋକଟା 2005 ରୁ ଆପଣଙ୍କୁ ଭରସା ଦେଲାଣି ଆପଣ ଏନଗେଜ ହେଲାଣି ଜେଲ କ୍ରିମିନାଲ ଅପିଲରେ ଲିଗାଲ ଏଡ୍ କାଉନସିଲ 2005 ମାନେ 18 ବର୍ଷ ହେଇଗଲା ଆପଣ ପ୍ରସ୍ତୁତ ହେବେ
ମଙ୍ଗଳବାର ଦିନ କରିବ ଆଉ सोमवार छुट्टी अच्छी 16 तारीख
अच्छा नेक्स्ट
item 33
32 टा कोन
32 नुआ एंगेज देला
ठीक है तापर 33
सुमन बोती जानी दे
33 34
पेपर बुक दे पूरा हैंड ओवर करियो आज Yes, 30.
Item 34.
33 and 34 also they will but she kali aji asini but he will contact.
Tapare
35.
35
My lord, on behalf of Mr. S.K.MISHRA, kindly taken on this matter next week, my lord.
Tapare
36
Item 37.
36
36 টা তো engage হলো
36 engage hela 37 Abbas Mahanti he was also present he will conduct.
Okay, next
38 also Lord Mishra.
S.K.MISHRA.
39 completed.
Item 40.
40 is already ଆମେ ଅଧା ଶୁଣିଛେ ସେଟାକୁ ସମ୍ମାନ ଟେକ୍ ଅପ୍ କରିବା।
କଣ ପାଇଁ ମାନେ ଅଧା ଶୁଣାଣି ଆଚ୍ଛା okay then
Item 41.
Item 41, I'm praying, can you taken up tomorrow on?
ନାଇଁ 41 ଟା ମାନେ ଏଟା ଆମେ ଯୋଉଟା ଥିଲା ଡିପି ଧଙ୍କ ଚାମ୍ବର ଥିଲା ପ୍ଲସ୍ ପ୍ରେମ ପଟ୍ଟନାୟକ ଏକ୍ସପାୟାର କରି ଯାଇଥିଲେ ଆପଣ କହୁଥିଲେ ଯେ ସେଥିରେ ସେ ଡିପି ଧଙ୍କ ଚାମ୍ବର କିଏ କରିବେ ଯଦି କରିବେ ସେଟାକୁ
ଯେହେତୁ ତା ସାଙ୍ଗରେ ଗୋଟେ ରେଗୁଲାର ଅପିଲ
ଆଜ୍ଞା ଆଜ୍ଞା
ଓକେ ଠିକ ଅଛି tomorrow all right that's all for today
ମେଲା
Yes, earlier he was on bail.
Cute.
Tired of it. So one resigned bail on the ground of sister's marriage. So other two face. But on that face that tomorrow, let's
yes
tomorrow.
हम देखिएगा ऊपर कपड़ा दिया yes Mr.
I have nothing more to add. They must start.
yes
May it please your lordship. My lords, this election petition has been filed to declare the nomination of the respondent, that is Mohammad Mukim, to have been improperly and illegally accepted, and hence the nomination is to be set aside. The entire process of election, so far as it relates to 90 Baravati Kattak Assembly, is vitiated, and the result of the constituency is materially affected, and to declare the said election void and to be set aside. My lords, the election petition has been filed mainly on 4 grounds. First, that the returning officer has improperly accepted the nomination form of the respondent, which is not in the prescribed form 2B, thereby, my lords, violating the mandate of section 33 read along with rule 4 of the conduct of election rules, section 33 of the RP Act. Then 2, the affidavit that has been filed, my lords, in form 26, my lords, in that affidavit, my lords, it is dated 3rd, which has been filed along with his nomination dated 2nd. My lords, thirdly, so this affidavit is non-est in the eyes of law, as it is an affidavit dated 3rd. The respondent has, my lords, this will be divided into 2 subgrounds, has stated false particulars, has given misinformation and stated falsehood about his criminal antecedents?
Just a minute. Yes.
And has not disclosed the criminal cases which have been, all the criminal cases which have been filed against him. Non-disclosure of criminal cases. And my lords, he has suppressed the property details and given misinformation, for which, my lords, his affidavit is vitiated and the election is liable to be set aside. This amounts to suppression and making a false declaration. My lords, this is in sum and substance my entire case. Now, before going into the law and merits, my lords, your lordships, I'm just pointing out, my lords, pleadings under Order 6, Rule 1. Which reads pari materia with 83(1)(a).
Yes.
My lords, pleading shall mean plain or written statement. Now, your lordships may, in order to constitute a plea in any pleading, my lords, this is a judgment 1990 Supreme Court, 99 Supreme Court, I will cite it. It has been held, courts must keep in mind that a plea is not an expression of art and science, but an expression through words to place fact and law of one's case for a relief. Such an expression may be pointed, precise, sometimes vague, but still could be gathered that he wants to convey through only by reading the whole pleading depends on the person drafting a plea. In India, most of the pleas are drafted by counsels, hence aforesaid differences of pleas which inevitably differ from one to other. Thus, to gather the true spirit behind a plea, it should be read as a whole. This does not distract one from performing his obligations as required under a statute, my lords. This is 99 Supreme Court. I'll cite it later on.
What,
Now,
please say the citation.
AR 99 Supreme Court. 99. AR 99 Supreme Court, page 3029.
What is the name of the party?
Party Nata. I'll give that. I'm a CPC quotage. Now, my lords, if your lordship comes to Order 6, Rule 2, pleading to state material facts and not evidence. Lordship gets it? Order 6, Rule 2. Pleadings to state material facts are not evidence. Every pleading shall contain and continue only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved. Lordship remembers that as per 87, CPC is applicable wherever, my lords, there are no specific provisions under the Special Act, RP Act. Now, my lords, if your lordship takes up 83, RP Act. (83) 1A. Contents of petition. An election petition shall contain a concise statement of the material facts on which the petitioner relies. B. It shall set forth full particulars of any corrupt practice that the petitioner alleges, including as full a statement as possible of the names of the parties alleged to have committed such corrupt practice and the date and place of the commission of each such practice, and shall be signed by the petitioner.
This case doesn't come within this.
This case doesn't come within the scope and ambit of corrupt practice, my lords.
Okay.
But the argument that has been led by the respondent is as if I am, my lords, pleading a case of corrupt practice, and hence they have said they should have included this, they should have included that. Having not included these facts, my lords, my case goes for a toss. So that is not the case. I have pleaded all material facts, and it has been so accordingly held by your lordships by dismissing their application under Order 7, Rule 11. Your lordships have come to the conclusion, because, my lords, Order 7, Rule 11 application is moved only when my plaint does not disclose a cause of action. A cause of action is established when I plead material facts. Once I plead material facts, once your lordships hold that there is a cause of action, the inference that is to be drawn is I have pleaded material facts for which I have established a cause of action. And once your lordship holds there's a cause of action to go to trial, my lords, all these argument of theirs that they should have pleaded this, they should not have pleaded this, this has been left out, everything goes back. I'll take your lordships to the judgment they have cited. I'll come to it. But I'm taking your lordships to your lordship's own order under Order 7, Rule 11, the conclusion. Code 22.
IA number 20, 2019.
IA number 20 of 2019. Page 214. Once this plea was raised, that it's an admitted position, my lords, if the plaint does not disclose a cause of action, the plaint is to be rejected under Order 7, Rule 11. They said that the plaint does not reveal a cause of action and does not, my lords, the election petitioner has not pleaded material facts. Your lordships, after examining the plaint, has held at this juncture, it cannot be said that the election petition suffers from omissions of material facts and it is incomplete and does not disclose complete cause of action. This is your finding, your lordships, under Order 7, Rule 11, which has been upheld by the Apex Court. So now, my lords, the consideration is whether the grounds that I have stated in my election petition, they have been made out or not. And if they have been made out, whether I am entitled to the relief or not. If they are made out, my lords, I am entitled to the relief. This is your finding, your lordships. This is the list decided between the parties. Why go to foreign judgments and other things? And my lords, this is the list decided between the parties, upheld by the Apex Court. So this list now rests. They cannot go on re-agitating that this is what they should have pleaded. This document should have been pleaded. This should not have been pleaded. They cannot say that. Now, my lords, they have relied, with your lordship's permission once.
Yes, please.
My lords, Virendranath Gautam, on which my learned senior has relied upon.
To para 35 only.
See, 83(1)A and 83(1)B.
Yes, my lords.
The difference is, so far as the 83(1)A is concerned, it states about the concise statement.
Yes, my lords.
Whereas in 83(1)B, it states about full particulars.
Full particulars of a corrupt practice.
Corrupt practice. So that is so.
If I will allege corrupt practice,
if I will allege corrupt practice, my lords, I'll have to state full particulars. This has been accordingly so held by the Apex Court. That there is only a necessity to state material facts, which I have done as per your lordship's ordered under Order 7, Rule 11. And material particulars are to be stated only when corrupt practices alleged. This very judgment on which my learned senior has relied upon, Virendranath Gautam, this makes it very specific. Citation is 2007, 3 SCC, page 617.
SCC page?
Page
617.
617.
Which paragraph?
2007, 3 SCC, page 617.
That I have noted down.
Yes, my lords.
They have cited up to para 35.
They have cited up to
para 35. No, which paragraph you are relying? Just tell me.
My lords, the entire.
This is T.M. Jacob.
No. Sorry, my lords, we have given the wrong judge. Virendranath Gautam. My lords, starting from paragraph 30, 30, 31, 32, 33, they are referring to other judgments. 34, what is the distinction between material facts and particulars? 34, your lordships. A distinction between material facts and particulars, however, must not be overlooked. Material facts are primary or basic facts which must be pleaded by the plaintiff of
34.
34, my lords.
34, it starts with on an additional ground also. This is Virendranath Gautam versus Satpal Singh.
Yes, my lords.
The reference is 2007, whatever you have given.
Yes, my lords.
SCC 617.
617.
But I think it is from Manu Patra, so you are holding the SCC online.
My lords, your lordships.
In which? 34.
Lordship gets it.
Yes.
A distinction between material facts and particulars, however, must not be overlooked. Material facts.
Yes. Please. Yes.
A distinction between material facts and particulars, however, must not be overlooked. Material facts are primary or basic facts which must be pleaded by the plaintiff or by the defendant in support of the case set up by him, either to prove his cause of action or defense. Particulars, on the other hand, are details in support of material facts pleaded by the party. They amplify, refine, and embellish material facts by giving distinctive touch to the basic contours of a picture already drawn so as to make it full, more clear, and more informative. Particulars thus ensure conduct a fair trial and would not take the opposite party by surprise. All material facts, paragraph 35, all material facts must be pleaded by the party in support of the case set up by him. Since the object and purpose is to enable the opposite party to know the case he has to meet with, in the absence of pleading, a party cannot be said to lead evidence. Failure to state even a single material fact hence will entail dismissal of the suit or petition. Particulars, on the other hand, are the details of the case which is in the nature of evidence a party would be leading at the time of trial. Then they quote Halsbury's Laws of England. My lords, paragraph 35, I pause here for a moment. My learned senior was saying that omission of a single material fact would entail in dismissal of an election petition. What they have meant to say, my lords, if you read the entire judgment, what they meant to say that in an election petition, for example, if I would have simply given the background of the case, these people had contested and the respondent's nomination has been improperly accepted and hence the election should be set aside. if that would have been the case, because then they would not know.
Hmm.
My lords, the condition precedent for the law of pleadings is they should know what I am trying to say.
Hmm.
They should not be taken by surprise.
Hmm.
So if I have not played even one single fact, material fact in the election petition, then Order 7, Rule 11 comes into operation, my lords. My election petition goes. But here, I will take your lordships to the plaint again. I have pleaded everything in clarity and it is not in form 2B. My lords, everything. I'll take your lordships. And they have replied to it. They have filed a written statement controverting each and every allegation. So, my lords, there is no question of taking them by surprise. I have pleaded all material facts. They have understood my case and they have replied to it. Led evidence also to that effect. We are now at the stage of trial, my lords. Trial is completed. We now.
You said you have suppressed criminal case. They said no, I have not suppressed. We filed
For example, we have said that he has suppressed criminal cases. They say no, we have not suppressed criminal cases.
we filed certified copies.
For that, we filed certified copies too.
These are not pleaded. Can I please say you have certified FIR number? These are particulars.
So basically, what Mr. Kanungo you want to contend?
Yes, ma'am.
That when they when the issues were framed,
yes, ma'am.
By that time the election petition was filed, this written statement was filed, list of witnesses was handed over, whatever it may be. So at that stage, when the trial commenced, it cannot be said that anything was kept secret from them.
I'm obliged. That's what I'm trying to say.
They were aware of what is the exact nature of accusation, or I'm trying to bring
allegation.
Yes. I'm trying to bring against the respondent, and accordingly, the fact that they have made each of the averments in their written statement and also
led evidence.
So it cannot be a surprise to
We have not taken them by surprise.
Merely some details have not been furnished.
My lords, I need not furnish.
Those are in the nature of
Those are in the nature of evidence.
Okay.
Those are particulars, my lords.
Okay.
I'll take your lordships to the plaint again. Every material fact I have stated. I have stated that he has not filed it in form 2B because this portion has been deleted. This portion has been deleted. 3A has been deleted. 2A has been deleted. 2 deleted. So it is not in the prescribed form 2B. I have said it, and it defeats the mandate of section 33 and rule read along with rule 4 of the conduct of election.
What they intend to say that you should have additionally pleaded that 3A form is this, and you should have mentioned this. You have he has not mentioned this in this way, in the detailed manner.
But detailed manner it is not necessary, my lords.
You have simply stated that this.
My case is that, my lords, that he has not filed. I'll take your lordships to the plaint, my lords. Let me complete this, and then I'll take your lordships to the plaint. Whether the question that will now be decided by your lordships, whether they have been taken by surprise. They have filed a detailed written statement. They have led evidence.
Whether they have filed a nomination in form 2B or not.
Yes. In Halsbury Laws of England, volume 36, it has been stated the function of particular is to carry into operation the overriding principle that the litigation between the parties, and particularly the trial, should be conducted fairly, openly, and without surprises, and incidentally to reduce costs. This function has been variously stated, namely either to limit the generality of the allegations in the pleading or to define the issues which have to be tried and for which discovery is required. Each party is entitled to know the case that is intended to be made against him at the trial and to have such particulars of his opponent's case as will prevent him from being taken by surprise. Particulars enable the other party to decide what evidence he ought to be prepared with and to prepare for the trial. A party is bound by the facts included in the particulars, and he may not rely on any other facts at the trial without obtaining the leave of the court. Thereafter, your lordships may, my lords, at paragraph 40 they say, we are unable to agree with the High Court. In our opinion, the considerations which weighed with the High Court were in the nature of evidence, which is a matter to be considered and proved at the time of trial. The High Court also was not right in virtually invoking the doctrine of estoppel and in dismissing the petition on that ground. My lords, paragraph 50. There is a distinction between facta probanda, the facts required to be proved, that is material facts, and facta probentia, the facts by means of which they are proved, that is particulars or evidence. It is settled law that pleadings must contain only facta probanda and not facta probentia. The material facts on which the party relies for his claim are called facta probanda, and they must be stated in the pleadings. But the facts by means of which facta probanda, material facts, are proved and which are in the nature of facta probentia, particulars or evidence, need not be set out in the pleadings. They are not facts in issue, but only relevant facts required to be proved at the trial in order to establish the fact in issue. In our considered opinion, material facts which are required to be pleaded in the election petition as required under section 83(1) of the Act read with Order 7, Rule 11A of the Code have been pleaded by the election petitioner. Cause of action has been disclosed in the election petition, and hence the petitioner could not have been dismissed by the High Court. Impugned order of the High Court is the High Court, in our considered opinion, stepped into prohibited area of considering correctness of allegations and evidence in support of averments by entering into the merits of the case, which would be permissible only at the stage of trial of the election petition and not at the stage of consideration whether the election petition was maintainable, and dismiss the petition. The said action therefore cannot be upheld and in order deserves to be set aside. On an additional ground, the order of the High Court is liable to be set aside. All allegations in para 8 of the election petition, as also subparas 1 to 4 of para 8, relate to improper and illegal reception and acceptance of votes, and the election petitioner has challenged the election of the returned candidate on the ground and not on the ground of corrupt practice. He was therefore required to state material facts in the election petition under section 83(1)(a) of the Act. It was, however, not necessary to set forth full particulars, which is the requirement of 83(1)(b) of any corrupt practice. So, my lords, the Honorable Apex Court themselves make out a clear distinction that once an allegation is made which is not that of corrupt practice, then only material particulars are to be stated. That is the statute. Material facts are to be stated. And if, my lords, I make out a case of corrupt practice, then material particulars also have to state. Their argument is, my lords, that I should have pleaded evidence also in my plaint. I should have also given bigger details, greater details. My lords, this all stands concluded by your lordship's own finding that material pleadings are there, cause of action has been revealed, upheld by the Apex Court. So, my lords, now I take your lordships. Your lordships, on the basis of pleading, has framed 38 issues, my lords.
Exhibit 1 to 48 you have marked.
My lords, we have marked exhibits 1 to 48 and they have marked exhibits A to FH2. They have examined 4 witnesses. Now, my lords, your lordships come to the first 3 issues That is whether the election petition as laid down is maintainable in law or not. That
ticket, just
yes,
issued. Yes. Yes.
My lords, the issues are, first issue is whether the election petition as laid down is maintainable in law or not. My lords, your lordships have already held it to be maintainable. Whether the election petition has cause of action to file the election petition or not, your lordships have already held that yes, there is a cause of action to file the election petition upheld by the apex court. Whether the election petition is liable to be dismissed under 86(1) of the RP Act 1951 for non-compliance of 81(3) of the RP Act 1951 or not. This third issue. Again, my lords.
During argument.
My lords, this issue has been again raised. My lords, initially your lordship remembers they filed an application under Order 7 Rule 11. They did not raise any issue regarding non-compliance of 117.
Exact and true copy of challan.
And exact and true copy of challan has not been supplied to us.
In the WS also no stand.
In the WS also no such stand has been taken. I have stated in my plaint.
Paragraph 9. Page 19.
If your lordship takes up my plaint.
Page 19.
Page 19.
Yes.
Paragraph 9.
Plaint.
Lordship gets it.
Election.
Election petition.
Election petition. Page
19.
Page 19.
19, yes.
19, paragraph 9. ठीक ଅଛି?
Paragraph 9.
9.
ଆପଣଙ୍କର 8 ତ ହନରେ that at the time of
presenting the election petition, the election petitioner has deposited a sum of rupees 2,000 towards security for costs of the petition as required under section 117 of the Representation of People Act and in accordance with the rules of the High Court along with the election petition.
They have not denied. WS page 87.
They have not denied this fact, Manoj.
Page 87.
Page 87. WS, Manoj.
Page 87.
Lordships may see paragraph 27. That the pleadings of the election petition in its paragraphs 1, 2, 3, 4, 5, 6, 7, 7A, 7B, 7C, 7D, 7E, 7F, 7G, H, I, J, 8 and 9 are all unnecessarily scandalous, frivolous, vexatious, and tend to prejudice and embarrass fair trial of the case, which is nothing but an abuse of the process of court, and such pleadings individually and collectively does not make out any complete cause of action, and therefore the election petition is liable to be dismissed at the very threshold for want of cause of action.
They have not pleaded that I have not deposited. I have not given exact and true copy of challan.
This is in relation to that issue number 3.
Yes.
Yes, Manoj.
Paragraph 9 of the election petition.
Paragraph 9 of the election petition, I have clearly stated that I have deposited.
There
page 27. Para 27.
Para 27.
Para 27 of the WS.
WS. They have not denied that I have not deposited this 2,000 rupees.
But stated that it is a vaguely stated, etc.
Yes, Manoj.
And on the other hand, the...
Be it as it may, Manoj. Your lordships held an inquiry.
And that order was passed.
That order was passed.
What is that order?
My lords, that is. My lords, order dated 23/9/22.
IA number 19 of 22.
That such an amount was deposited, in fact, with the file.
That order dated 23/9/2022 in IA number 19 of 2022.
IA number 19 of 2022.
2022.
2020.
22, 19 of 2022. They have not raised all these.
Lordships may take up that order. Your Lordships will see that such an issue has not been raised by them, while contending that I have not deposited, that I have not complied with 117 of the RP Act. Lordships may take
You
up.
want to place that order?
Yes, Palak.
इस order टा देख लो ये order sheet नहीं order sheet पूरा total case ର order sheet କେବେକାର କହୁଛନ୍ତି
23/22 in IN number 19 of 22. Lordship gets it?
Just a minute.
This.
Just a minute.
Sorry.
Argument stage of question, the exact and true copy the new ground agent.
तेईस नो 22 in IN number 19.
Yes. 19 of 22.
The election
matter is taken up through hybrid arrangement. Right. Application has been filed by the respondent Muhammad Mukim for dismissal of the election petition number 6 of 2019 under section 86(1) of the Representation of People's Act on account of non-compliance of provision under section 117 of the 51 Act. Learned counsel submitted that since at the time of presentation of the election petition, the election petitioner has not complied with the provision under 117 of the Act, the election petition is liable to be dismissed in view of the mandate under section 86 of 1951 Act. Section 117 of the 51 Act reads as follows. Your Lordships have quoted the section. On 9/9/2022, Mr. Bidyadhar, this is very important, Mr. Bidyadhar Mishra, learned senior advocate appearing for the respondent, referring to Annexure A, which is the challan of deposit of rupees 2000 with the cashier, submitted that Rule 1 of Chapter 22 of the Rules of High Court of Orissa 1948 has not been followed while issuing such challan, which is to be filed along with the election petition, and the entry of that deposit has also been mentioned in different things. While stamp reporting the election petition on 18/7/2009, which creates suspicion as to whether the aforesaid amount of rupees 2000 was deposited on 3/7/2019 and subsequently, and whether challan of deposit was filed with the election petition or not. Mr. Milaga appearing for the filed objection. For better appreciation of the contentions raised, a report was called from the learned registrar judicial as to whether the cash of 2000 has been deposited on 3/7/2019 and the challan as has been annexed to the election petition was issued on the very day or not, and filed with the election petition on that day and or not, and the report was also directed to indicate whether Rule 1 of Chapter 22 of the Rules of High Court Orissa 1948 has been followed or not. In pursuance of such order, learned registrar judicial of this court has submitted the report dated 16/9/22 in a closed cover, which indicates as follows. For compliance of the order of the Honorable Court, reports were called for from the cashier and superintendent MG section of the court. They have submitted the reports placed at flags A and B respectively. The cashier has reported that deposit of cash of rupees 2000 was made on 3/7/2019 with challans in triplicate filed by the learned counsel for the petitioner towards security deposit in election petition number. That time it was not numbered. Devashish Samantray versus Muhammad Mukim. He, being the cashier, received the challans and cash of rupees 2000 only towards security deposit in the above election petition, and the above amount was deposited via challan number 18 dated 3/7/2019. Thereafter, one copy of the deposited challan was handed over to the learned counsel for the petitioner. Second copy of the challan was sent to the MGC section to be kept with the record, and kept the third copy of the same serially in the guard file of the account section. A photostat copy of the challan kept in the account section furnished by the cashier along with his report is placed at flag C. The superintendent MG section has also reported that during presentation of the election petition before the registrar judicial, the challan showing deposit of rupees 2000 was stacked with the election petition and has been marked by the registrar judicial in the first page of the election petition. A photostat copy of the challan filed by the petitioner at the time of presentation of the election petition and copy of the first page of the election petition bearing endorsement of the registrar judicial are placed at flag D and E. Basing on the reports of the cashier and superintendent MGC section, it is humbly submitted that a cash of 2000 had been deposited on 3/7/2019 with the cashier. The challan was issued on 3/7/2019 and it was filed with the election petition on 3/7/2019. It is humbly submitted that Rule 1 of Chapter 22 of the Rules of High Court had been followed while filing the election petition. From the report of the learned registrar, it appears that the government's taken in the IA that there has been non-compliance with the provision of Section 117 of 1951 Act at the time of presentation of the is not acceptable. Earlier, the respondent has filed interim application order 6, Rule 16 and Order 7, Rule 11, read with such and such, read with Section 83, 86, to praying to strike out the pleadings made under 7A to 7J of the election petition filed by and also with a further prayer to reject the election petition at the very threshold in its entirety for want of cause of action without entering into the merits of the case, which has been dismissed as per order dated 26/22. Challenging the said order, the respondent moved the Honorable Apex Court, Supreme Court in special leave to appeal C number 12653 of 22, which has been dismissed as per order dated 29/7/22. Considering the submissions made by the learned counsels for the respective party, I am of the humble view that filing of this IA is an attempt just to delay the trial of the election petition. Prayer made in the IA is totally baseless. So, your lordships,
you have complied section.
Order 7, Rule 11, my lords, they do not raise this plea. Neither in the written statement they say that we have not deposited 2000. Then they file another application saying that, as I've showed, their averment was that I have not complied. It is in some different ink and other things, my lords. The office gives your lordships a report that yes, 2000 has been deposited and challans had been issued. Now again they come up with a plea.
Exact and true copy of challan not served.
Exact and true copy of the challan has not been served upon them.
Not so kindly say exhibit.
Now, first thing, my lords, challan is not a part of the election petition. Challan we annex to the election petition only by way of practice to show that yes, we have deposited the costs. It is not a part of the election petition.
Exhibit AD.
Exhibit AD by 1 is the challan appended to the original election petition. Your lordships may see Exhibit AD by 1.
And
AB by 2 and AC by 2. AD by 1.
B by 1.
AB by 2 and AC by 2. These are the three challans in triplicate. Their averment was that I have, without depositing this amount, I have given the challan. I have xeroxed it and given it along with my election petition. Your lordships may kindly see. AD by 1.
Signature.
Again, signature
Below receive payments.
Receive payment and
Signature of the cashier.
Signature of the cashier. Everything is there, ma'am.
Challan number date. Same as report.
Eta AB by 1.
AD. Exhibit AD.
D for Delhi.
AD by 1. Challan appended to original election petition.
AD by 1 to?
Yes.
ଏଟା ତ କଣ ଗୋଟେ seal ଟା ମରା ହେଇଛି ତା ଦେହରେ ଲେଖା
Seal mara ହେଇଛି received rupees 2000. Then signature of the cashier with date.
କୋଉଟା ଏଟା ଜଣା ପଡୁନି କିଛି
Below. ତଳେ received payment. ତଳେ ଆଡେ right side.
Cashier's memo ଯୋଉଟା.
ଏଇଟା ନୁହେଁ କି AD by 1 AD ହଁ ନାଇଁ ये जो साइड रे लिखा है कौन येटा
नहीं चालान टा अछि प्रिंटेड चालान टा
अच्छा
फिर देखो मैं सर्टिफाइड कॉपी दूची
देखिए देखिए
एटा इलेक्शन पिटिशन संगे थबो एग्जिबिट टा इलेक्शन पिटिशन रो लास्ट पेज एडी मार्क है इलेक्शन पिटिशन
AD by 1.
हाँ ये ता से ये लगी
से इलेक्शन पिटिशन रो पार्ट तो से ता संगे अछि
आया देखिए cashier has received the amount
हम्म
which is also fortified by the report.
डेट भी पड़ी 3/7/2019
3/7 then left hand side रे चालान नंबर डेट ऑफ डिपॉजिट चालान लेफ्ट हैंड साइड चालान नंबर 18 dated 3/7/2009 भी पड़ी
19.
2019 now your lordship kindly see exhibit A by 2
A/2 दा वर्क
AB by 2
A/2 ना AB
by 2.
AB टा होची इलेक्शन पिटिशन से फाइल कर कोर्ट रे दाखल करचंती एंड AB by 1 is the summon AB by 2 is the चालान
And AC by 2.
AB AC सेम अछि गोटे थ्रू प्रोसेस पाइचंती गोटे पोस्ट रे पाइचंती AB by 2 सर देखिए तले से केवल सील टा उठी नहीं सिग्नेचर ऑफ द कैशियर इज देयर the amount has been mentioned date has been mentioned it is exactly same what is in exactly AD by 1 except seal and चालान number date are also exactly in the same handwriting same there so it's not that we first xerox and supplied them
Right, Achita.
check कर देगी दूसरी
ठीक है
ठीक है
कारण इनफैक्ट से सील टा नहीं एटी मींस
हाँ again that has been held by my lords seal my lords they are not prejudiced in any manner if the seal is not there.
the question is that whether that challan has been filed or not that
that is the, my lords
what they say that exact it is not the exact copy of what has been marked on your behalf that challan because that seal was not is not there.
Yes my lords. Your lordships I'll take your lordships to two judgments of the apex court. गोटेरे notary seal बाजी नथला. There the apex court said that exact and true copy doesn't mean that it has to be exactly the same. Only thing is it should not mislead the other party. That এটা and he is prejudiced by such by being misled. My lords, this is a constitutional bench judgment that is
seal बाजी नोटरी रो
ସେମାନେ ଯୋଉଟା ପ୍ରମାଣ କରିଛନ୍ତି ସେଟା ହଉଛି ଏକ୍ସିବିଟ୍ AC/2
AC by
ये जो चालान टा जोड़ा आपण ताऊ कॉपी देइथे
AB by 2 and AC by 2
हां
Aye.
exhibit AB by 2
and AC by 2.
exhibit AC by 2 according to them it does not matches
Exact and true copy of AD by 1.
with AD by 1
And this was not their plea in their written statement, either in the Order 7 rule 11 application and in the
first
subsequent
application.
application.
First application filed for dismissing my my plaint for non-compliance with 117. My lords, your lordship is aware that section 11 of the CPC is applicable. That means constructive res judicata is also applicable. A point which ought to have been raised and has not been raised cannot be raised at a subsequent stage. Anyway, that's a technical plea, my lords. I'm taking your lordships. TM Jacob versus C follows.
99-2 SCC.
99.
Sorry.
99.
99-4 SCC 274.
274.
13.
My lords, your lordships may take up para 10.
what is the reference
My lords, 99
4 SCC.
4 SCC 99 4 SCC page 274.
party na kono
TM Jacob versus C follows. This is a constitutional bench.
which paragraph
Paragraph 10, my lords, then other paragraphs. What was the issue before the Honorable Apex Court? Lordship gets it. Paragraph 10. After leave was granted by this court, the following order was made on 18/12/97. The main point urged by the learned counsel for the appellant is that a copy of the affidavit supplied to the appellant together with the notice of the election petition is not a true copy inasmuch as it does not indicate the name and designation of the notary, nor does it bear the seal and stamp of the notary. On this basis, it is contended there is non-compliance of 81(3), because of which the election petition is liable to be dismissed at the threshold under 86(1) of the Representation of People's Act. Shri Sorabji, learned counsel, and then your lordships may come to Vice.
Judgment referred.
My lords, paragraph 23 onwards.
yes
Judgment referred.
This was the issue before the Apex Court, now 23. Reverting now to the facts of the present case. A perusal of the copy of the affidavit served on the appellant shows that the copy of the affidavit supplied to the appellant contained the endorsement that the affidavit had been duly affirmed, signed, and verified by respondent number 1 before a notary. Under the affirmation by the notary, the word signed notary was also written. Which was, however, found missing in the affidavit was the name and address of the notary, as well as the stamp and seal of the notary before whom the affidavit had been so affirmed and who had attested the affidavit. The defect found in the present case is almost identical to the defect which had been found in the copy of the affidavit supplied to the first respondent in Anil Deshmukh's case. Then your lordships may straight away come to para 31. The next question which still arises for our consideration is whether the election petition in the present case was liable to be rejected in limine for non-compliance with 81(3) read with 86(1) of the Act on account of the defect in the true copy supplied to the respondent. Precise objection goes, my lords, 34. Section 83 deals with the contents of the petition and the proviso to subsection 1 of 83 lays down. Now, 35. Does the word copy occurring in 81.3 of the Act means an absolutely exact copy, or does it mean a copy so true that nobody could be by any possibility misunderstood it? This matter is no longer res integra in Murarka Radheshyam Ram Kumar versus Roop Singh Rathore and others. My lords, 1963, a constitution bench of this court elaborately dealt with this question after referring to a catina of authorities. It was held that the test to determine whether copy was a true one or not was to find out whether any variation from the original was calculated to mislead a reasonable person. This is the crux of the matter. The Constitution Bench found as it untenable for the contention that since copies of the petition served on the returned candidate did not contain signatures of the petitioner below the word petitioner on the copies of the petition served on the respondent, they had ceased to be true copies of the original petition, attracting the consequences of 86(1) of the Act. The bench opined, having regard to the provisions of Part 6 of the Act, we are of the view that the word copy does not mean an absolutely exact copy. It means a copy so true that nobody can by any possibility misunderstand it. The test whether the copy is a true one is whether any variation from the original is calculated to mislead an ordinary person. Applying that test, we have come to the conclusion that the defects complained of with regard to the election petition 269 of 62, which were not such as to mislead the appellant. Therefore, there was no failure to comply with the last part of subsection 3 of section 81. In that view of the matter, subsection 3 of section 90 was not attracted, and there was no question of dismissing the election petition under that subsection by reason of any failure to comply with the provisions of section 81. The bench also opined with when every page of the copy served on the appellant was attested to be a true copy, my lords. Similar view was 37. Similar view was reiterated by another constitution bench. My lords, paragraph 38. The object of serving a true copy of an election petition and the affidavit filed in support of the allegations of corrupt practice on the respondent in election petition is to enable the respondent to understand the charge against him so that he can effectively meet the same in the written statement and prepare his defense. The requirement is thus of substance and not of form. The 39. The expression copy in section 81(3) of the Act, in our opinion, means a copy which is substantially so and which does not contain any material or substantial variation of a vital nature as could possibly mislead a reasonable person to understand and meet the charges allegation made against him in the election petition. Indeed, a copy which differs in material particulars from the original cannot be treated as a true copy of the original.
ଯୋଉଟା ବାହାର କରିଦେଲୁ ଏ B/2 ଆଉ C/2
Paragraph.
I believe Mr. Vishwas.
Yes, please.
No, I know.
If Mr. Kanungo,
Yes, sir.
if that particular seal is missing,
My lords.
then rest of the thing,
Yes.
from the rest of the thing which has been there in the AB2,
Yes, sir.
how can it actually be said, or it can be you will understand that in fact this amount has been deposited. It's no doubt it's a challan, it has been filled up, but from the side of the High Court, what is the that if the seal is not there, then what would be impression they will gather that no, in fact, it has such a deposit has been made, because the seal is the only of the High Court. The rest of the things are been by you.
উপরে seal ଅଛି,
ଉପର seal ଟା ହଉଛି ସେଟା ହଉଛି
register and date of deposit ଅଛି.
କୋଉଠି?
Date of deposit, cashier's member, date of deposit 3/7/2019.
ହଁ ଏଇଟା ରହୁଛି ବ୍ରଜ।
Date of deposit, ଚାଲାନ number ବି ଅଛି।
ଚାଲାନ ନମ୍ବର କାଇଁ?
18
ତା ଉପରେ just ସେଇ date ଉପରେ।
Date ଉପରେ
date of deposit और number of deposit। हाँ।
ଆଏ।
And you have not taken, there is no time that I have not deposited.
Date of deposit ରହିଲା ଆଜ୍ଞା। Date of deposit is clear. Challan number is given. Number of deposit is given. And accept signature on the malots.
ଆଉ କୋଉ signature ଅଛି?
Right side ରେ signature ଅଛି।
କାହାର?
ସେ ଯୋଉ ଟଙ୍କା
ଟଙ୍କା ନେଇଛି କ୍ୟାସିୟର ଯେ ନେଇଛନ୍ତି।
ଓ ଏଇ ଯୋଉ 2000 ଲେଖା ହେଇଛି।
ଆଜ୍ଞା
2000 words ରେ
letter ରେ words ରେ ଲେଖା ହେଇଛି। ସେ can they be misled?
ନାଇଁ ମୁଁ ସେଇ ଜିନିଷଟା ପଚାରୁଛି। ମୁଁ କହିଲି ଖାଲି
and that is not the stand from the very beginning.
That I have not deposited.
That I have not deposited.
You mean to say that along with the suppose seal is not there, but these things would not have been there. That is cashier memo जो date टा पड़ीची, एगुड़ा नथांदा, signature एगुड़ा total नथांदा।
ताहले ओटा अलगा कथा गया। They stand that I have given them a Xerox copy prior to deposit. ताहले अलगा कथा। And my lords, the Supreme Court again says that deposit of amount is mandatory for 117. Rest is all directive. That is, tabara challan is not a part of the election petition. I'll show your lordships what is an election petition. Challan is not a part. We only annex it for the purpose of, my lord, it's a practice to show that we have complied with 117. I have to give them a
no. It is a precondition. You can say it's a precondition for filing the election petition. It has, if you do not deposit that,
then my election petition.
Right. So that is
so the endorsement is there on the election petition by the Registrar General. Your lordship see the first page of the election petition.
No, the
at
that I've seen that
register
the copy which has been supplied to them,
that also filed along at the time of filing election petition.
In their copy, that is that endorsement.
Yes, well.
Your lordship kindly see the top endorsement by the Registrar Judicial. I have presented original election petition along with so many copies.
Just a minute, just election petition of ours. प्रथम पेज टा बुझें। हाँ नहीं सेटा address statement.
The election petition.
Address statement छाड़ दिया था पर हाँ इटा
left hand side endorsement by the Registrar Judicial.
The election petition presented by G. So
petitioner on behalf of the petitioner Shri Devashish Samantray.
2000 is okay received.
Is annexed. Then
okay, so this
court fee worth ₹6, process fee worth 5. Filed requisites both way. Is filed. Oh, whatever election petition was filed before this court, the same copy was also filed before the Registrar Judicial, which were served them through process and through court, post.
Okay, yes, come to the next one.
My lords. Then, this is barred by constructive res judicata, I've already said, my lords. Then, my lords, this is a 3-bench judgment of the Apex Court, 2002, 7 SCC, page 289.
Just
condition on the deposit.
2003.
2002.
2002, yes.
7 SCC, page 289.
What is the name of the party?
My lords, M.Y. Ghorpade.
Thank you.
GHORPADE. RPADE.
Which paragraph?
My lords,
Yes,
the judgment says 117. My lords, appeal is directed against the order contested challenging the election. Filed an application for the dismissal of the election petition under 86 of the Act on the ground there has been non-compliance with 117 of the Act. High Court, by the impugned order, having rejected the preliminary objection and having held the election petition to be maintainable, the present appeal has been preferred. The only question that arises for consideration in the appeal is whether there has been non-compliance with 117 of the Act. Section 86 of the Act in Chapter 3 deals with the trial of an election petition. 86(1) states that the High Court shall dismiss an election petition which does not comply with the provisions of Section 8 or 82, 81 or 82 or Section 117. 117 of the Act deals with the security for costs and reads thus. There cannot be any dispute that if the High Court comes to the conclusion that the election petition had not complied with the provision of Section 117, then that election petition has to be dismissed. The appellant alleged that a sum of 2,000 had been deposited in the High Court of Karnataka by Hiroji Lad, respondent 5, and not by Shivaji Rao Pol, the election petition, and therefore there has been non-compliance with Section 117 of the Act in as much as under the aforesaid provision, the requirement of law is that the petitioner shall deposit in the High Court in accordance with the rules of the High Court a sum of rupees 2,000 as security for the cost of the petition. The High Court considered the averments made in the election petition to the effect that the petitioner had deposited the sum of 2,000 in the name of respondent 5, and also the evidence of respondent 5 indicating that he had never deposited the security amount of 2,000, and it is the election petitioner who had deposited and considered the provisions of the rules of Karnataka High Court as well as the document PY5, which has been enclosed with the election petition, and came to hold that the deposit in question had been made by the petitioner and the same has to be taken as security for the cost of the election petitioner, and as such there has been compliance with Section 117 of the Act. And coming to this, my lord's conclusion. S.S. Jawali, appearing for the contended, is wholly erroneous, according to the learner, because, my lords, thereafter, Paraphrase. Before examining the different decisions of this court on which the parties have relied upon and looking at the provision of Section 117 of the Act, it is crystal clear to us that the aforesaid provision requires deposit of 2,000 as security for the cost has to be made at the time of presenting an election petition. The object of having the aforesaid petition could be to discourage entertaining frivolous election petitions and to make provision for cost in favor of the parties who ultimately succeed in the election petition. Subsection 2 of Section 117 authorizes the High Court to call upon an election petitioner during the course of the trial of an election petition to give such further security which may be necessary depending upon the facts and circumstances of the case. It would therefore be apparent that the requirement of making a security deposit of 2,000 is mandatory, and the same has to be made while presenting an election petition. But the mode of deposit as well as the person who could make a deposit has to be complied with in accordance with the rules of the High Court in question, and as such been held to be directory in several decisions of this court. Then they discuss all the judgments, my lords. Para 9. In Karunanidhi versus M.B. Hande, provisions of Section 117 of the Representation of the People Act directly came up for consideration. In this case, the Assistant Registrar of the High Court directed that the amount of security be deposited to the credit of the Registrar of the High Court in Reserve Bank of India, and in pursuance of the direction, the election petitioner deposited 2,000 with a 3-receipted challan by the Accounts Department to the credit of the Registrar of High Court, and Reserve Bank of India made the endorsement that it had received in cash. The contention of the applicant assailing the maintainability of the election petition was that there has been non-compliance with 117 of the Act, in as much as Rule 8 of the election petitions rules provides that money should be deposited in the High Court in cash and that rule must be held to be forming a part of subsection 1 of section 117. It was thus contended that the deposit of money in Reserve Bank of India to the credit of the Registrar High Court cannot be construed to be in compliance with the mandatory requirements of 117(1) of the Act. This contention was repelled by this court, and it was held there was nothing wrong in the procedure adopted in making the deposit when the amount so deposited with a pre-receipted challan issued by the Accounts Department to the credit of the Registrar High Court and Reserve Bank of India made the endorsement received in cash. It must be regarded that the payment has been made in the High Court, and the pre-receipted challan bearing the endorsement must be treated as the receipt of the registrar. This court relied upon the earlier decisions of this court, which was a case under provisions of 117 as it stood prior to its amending, wherein the receipt showed that the deposit had been made but did not show that the deposit had been made in favor of the Secretary of the Election Commission. One of the questions that arose was whether the expression in favor of the Election Commission contained in section 117 as it stood then was mandatory in character or not, and this court held that the first part of section 117 was mandatory but not the latter part. But it is not necessary to multiply authorities on the part, but suffice to say that the sum of rupees 2,000 must be deposited while filing an election petition, and that is undoubtedly mandatory, but through whom the amount will be deposited, etc., cannot be held to be mandatory. This being the position, and in the case in hand, the evidence of the election petitioner as well. So they dismiss the. So, my lords, the first portion. Your lordships have conducted a thorough inquiry and have found out that 2,000 rupees has been deposited. Registrar has also endorsed this. And in the election petition, the receipt challan itself, the challan number has been given, and receipt signature of the cashier is there, date on which this has been received, everything has been given. Moreover, my lords, my lords, challan is not a part of the election.
That decision, have you got any, sir? That challan is not a part of that.
My lords,
challan part बोले कि नहीं है affidavit देंगे बोले it is not
the
I'll show your lordship.
It's all right.
Proper judgment.
Just make a note of it.
Yes,
if you get it, yeah, give.
Yes,
because
from a bare reading of the act,
because what you have pointed out that deposit of 2,000 is mandatory.
Mandatory.
So the document must be there along with the endorsement to show that such a deposit has been made, and the other side should also be made aware of it.
Yes,
that you have complied that
provision. In the election.
And we have avoided in the election petition. They have not disputed.
That you are right. And that endorsement is there, and the challan you have given, but the missing seal
missing seal, my lords, there also the notary seal was missing. They said that exact and true copies doesn't mean that it has to be exactly the same. The only thing that your lordships are to adjudicate is whether they have been misled by any by the missing of the seal. Because the rest of the facts are there, my lords. They could,
misled by missing of the seal.
And they have not even raised a contention before your lordships that they have been misled by the missing of the seal. Rather, it is a belated plea taken by them. Initially, they raised the plea that 2,000 has not been deposited. They raised suspicion regarding, my lords, different inks being used by the cashier. That was repelled by your lordships with the inquiry. Again, they raise this plea. That means they go on raising plea after plea after plea, my lords, somehow to scuttle the election petition.
Yes.
my lords. Another judgment that I'm citing before your lordship is
It's on which point, sir?
same point, my lords. Just one more. It's an old judgment, 1950 AR 1959, Supreme Court, page 837.
8?
837.
AR 1959, Supreme Court, page 837.
Yeah, just
Om Prabha Jain versus Dhyanchand and another.
Om Prabha Jain versus Yanchand and another.
Para 17.
Para 17.
Last but one page.
As to the merits of the appeal, we find no difficulty. Under Section 117 of the Act, the Treasury receipt has to show a deposit of 1,000 in favor of the Secretary to the Election Commission. There is no dispute that the respondent deposited the required amount and enclosed a deposit receipt with the petition. The deposit receipt filed by the respondent contained the following statement on which the appellant's contention is based. By whom tendered? Yanchand. Name of the person on whose behalf money is paid? Secretary to the Election Commission. The contention is that the receipt in this form showed that the money had been paid by the respondent acting for the Secretary to the Election Commission and not by him in favor of the latter. We are wholly unable to read the deposit receipt in that way. The second of the two entries reproduced above is intended to indicate the person on whose favor the money has been paid. On whose behalf here clearly indicates on whose favor or whose benefit. The form of the receipt contains no other heading for indicating the person in whose favor the money was paid, and of course, it was paid in favor of somebody. That makes it perfectly clear that the words on whose behalf means in whose favor. It would be absurd to think that the respondent had paid the money into the treasury as security for the cost of the election petition, acting as the agent of the Secretary, Election Commission, which would be the position if he were to accept the appellant's contention. We feel no doubt that the receipt was in full compliance with Section 117 of the Act.
अच्छा खाली just
Om Prabha Jain versus Yanchand.
Mr. Kanungo,
Yes, sir.
मने करंतु आपण जने इलेक्शन पिटिशन धरिकिन आसिला हाई कोर्ट को फाइल करिया पे
Aye.
तो इलेक्शन पिटिशन आनची वकालतनामा करिया सब ठीक अछि ए जो चालान टा किनिला चालान किनिकिन ता fill up kala pare jehetu it is to be that deposit has to be made along with the election petition ତେଣୁ ପ୍ରଥମେ ଆଗେ ସେ ଯୋଉ 2000 rupees ଟା deposit କରି ଚାଲାନ ରେ ତାର endorsement ନବ
Aye.
ଠିକ ତ
Aye.
then ସେ ଚାଲାନ ଟାକୁ ଗୁନ୍ଥିକିନି ଇଲେକ୍ସନ ପିଟିସନ ସହିତ ରେଜିଷ୍ଟର ଜୁଡିସିଆଲଙ୍କ ପାଖରେ ପ୍ରେଜେଣ୍ଟ ହବ
Aye.
ତ ରେଜିଷ୍ଟର ଜୁଡିସିଆଲ obviously ଏଇ ଯୋଉ endorsement ଦେଖିଛନ୍ତି ତେଣୁ ଚାଲାନ ଥିଲା ବୋଲି ସେ ଲେଖିଛନ୍ତି ଯେ 2000 ଟଙ୍କାର ଡିପୋଜିଟ ହେଇଛି ଏବଂ ଏଇ ଇଲେକ୍ସନ ପିଟିସନ ସହିତ ଆପଣଙ୍କୁ ବାକି ଅନ୍ୟ ଯେତିକିଟା ରେସ୍ପଣ୍ଡେଣ୍ଟ ଅଛି ତା କପି ମଧ୍ୟ ସାଇମଲ୍ଟେନିୟସଲି ଦବାକୁ ପଡିବ even though by that time the order has not been passed or it has not been placed with page ଟା ଆସିବ whether that endorsement the register has to make in every ତେଣୁ obviously ତାଙ୍କ ପାଇଁ ଯୋଉଟା ଡିପୋଜିଟ ହେଇଥିବ ତା ଧିରେ ସେ endorsement ଥିବ ବୋଲି କେମିତି ଆପଣ କହୁଛନ୍ତି
ମୁଁ sir ଟିକେ procedure କହି ଦଉଛି
ହଁ procedure ଟା କଣ
suppose a person comes to file a election petition if a challan is purchased filled up then that challan we have to take to the deputy register judicial your lordship will get the seal of the deputy register at the top of the challan
challan ଟା ବାହାର ଆଉଥିବ ରୁଣ ହଁ ସେଉଟା
top re jo seal odisha high court deputy register deputy register will allow us then it has to be taken to the section mjc section upar agar top re rekha hai valid for today
ନା ନା ଏଇ ଯୋଉ सीलटा जो मराला
हाँ।
एटा कोन से 2000 टंका रखिला परे
नाइ 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 आमे डेप्यूटी रजिस्टर को चालान दबु
अच्छा
he will send it to the section
ओके
triplicate रे चालान फाइल हबो डेप्यूटी रजिस्टर पाखरे he will send it to the section MJC section top रे MJC section will pass it valid for today with initial signature we will take it from the section and then go to the cashier cashier पाखरे deposit करिवु then he will receive the payment endorsed it चालान नंबर तांकर register रे entry करिवे चालान नंबर करिकि he will give one copy to us one will be kept with the cash section and one will send to the MJC section
ओके
thereafter we xerox it original टा रहिबो election petition संगरे xerox copy लगेबु जेतले register को हमें present करूचु register also calls superintendent of the section कि सबु देइचन कि नै verify करो कोर्ट फी दिया कि नहीं डॉक पिटिशन ठीक अछि कि नहीं वेरीफाई कला पर रजिस्टर मेक्स एन एंडोर्समेंट दिस इज द प्रोसीजर
से जो साइड रे जो
एंडोर्समेंट कर बिकॉज़ इलेक्शन पिटिशन हैज टू बी प्रेजेंटेड बिफोर द रजिस्टर इन पर्सन
नै मु कहया कथा आ गोटे खाली कोंतु जदी आपण एई जो प्रोसीड्यूर टा कहिले ता माने तीनिटा जाक जो कॉपी चालान रे सील रहिथिबो
आज्ञा
जोटा कि दीटा ऑफिस रिटेन कर दोची गोटे एमजेसी सेक्शन करची गोटे आ गोटे रखुछन
कैशियर एमजेसी गोटे हमकु
आ गोटे आपन देले आपण कहउछंती जे जेतेबेले इलेक्शन पिटिशन टा फाइल करिवे एईटा को मध्य फाइल करिवे आ जेतिकीटा पार्टी अछंती
तांका पिटिशन संगरे भी हमें
तांका संगरे तार जेरॉक्स करिकिन देबे
हमें लगौछु देयर इज नो रिक्वायरमेंट
अच्छा हेला
हमें दौछु अने टू शो दैट वी हैव डिपॉजिटेड द
कहवा कथा जोटा कि कंटेंशन होची इनफैक्ट जदी एईटा प्रोसीड्यूर हुए ताल से सीलटा मिस करिवो केमती जेरॉक्स कले
इट मे बी जेरॉक्स टाइम रे केतल उठी नै कि कोठी रहि जाई इफ योर लॉर्डशिप कंपेयर्स एग्जिबिट AD1 एंड AB2 AC2
नहीं सी जो ता तळ सिग्नेचर टा उठी छी ना
सिग्नेचर टा अछि कैसे
हेडा उपटा केमती उठी
सील टा केमती लाइट
आपण
इट मे बी लाइटर जेरॉक्स
जस्ट कहू यदि सेया एया प्रोसीड्यूर हुए सबु जिनस उठिबो 18 नंबर उठिला 3/7/2019 रखिला से कैशियर सिग्नेचर जोटा कि से रिसीव्ड पेमेंट भितरे करिछि सील भितरे सेईटा उठिला ए जो रिसीव्ड पेमेंट रो सील टा केमती उडी जिवो
से आज्ञा केमिति जेरॉक्स एटा मिस हेछि it has been mixed somewhere in the xerox but it the signature your lordship compare the signature
सी तांकर कंटेंशन होछि
exact and true copy not supply and we have xerox first annexed it and deposited the amount subsequently
से सील टा जो बाजीची से कहउचंदी परे बाजीची माने सील टा पछरे बाजीची सेतेबेल को सब एई जो बाकी तक एंडोर्समेंट हेकिनी जेरॉक्स कर जाइतला ए सील टा सेतेबेल बाजी नथिला
unless I deposit आगे मु डिपोजिट करी कि इलेक्शन पिटिशन ओरिजिनल संगे न देले रजिस्टर रिसीव केमती करिवे रजिस्टर एंडोर्समेंट केमती करले
नहीं नहीं दैट्स वन पार्ट ऑफ इट हमें सी जो कंटेंशन टा रेज कर प्रैक्टिकली हमें इफ वी थिंक
जदी मु आगुरु जेरॉक्स ए कैशियर सिग्नेचर न थांता
न कैशियर सिग्नेचर अछि जे कैशियर सिग्नेचर सहित सील टा मारी नथिबो जदी अपन जस्ट विजुअलाइज ट्राई टू एक्सप्लेन इट अवे कैशियर सेतेबेले सील टा नाही सी आपन कहला जे आज्ञा
मते देई देला मु आनी के एनेक्स करी दे दैट मे बी
आपण आपण नै जानू एंडोर्समेंट तो रहिला मु नै किनी
दैट मे बी मिलॉर्ड
हां
बिकॉज़ आई हैव दिस अमाउंट वाज डिपॉजिटेड बाय माय क्लर्क
हां कैशियर सब कर देला
से देई देला हम एनेक्स करी के देला
सिग्नेचर ही मार देला कहला आज्ञा सील टा वर्तमान पाउनी कि कोन कोन आपण डिपॉजिट कोन मु जाई किनी सील टा मार दोची बा
नहीं से चालान हमकु देई देला डिपॉजिट रिसीव कर देला आगे
2000 टका डिपॉजिट हला एंडोर्समेंट देला चालान नंबर पड़िला डेट पड़िला ता सिग्नेचर रहला सील टा सेति बेल को संभाव रहता
आ गोटे जिंस आगे स्टैंप रिपोर्टिंग जेतले हबो स्टैंप रिपोर्टर इज टू आल्सो वेरीफाई दैट माय इलेक्शन पिटिशन along with the copies are in order so there is no report by the stamp reporter that amount has been not deposited or challan is not there
That might be the position as your lordship is saying.
ଭାବୁଛି
ସେ ହଠାତ୍ କରି ପାଇ ନଥିବ, but the
ସେଇ
factum of deposit of
ନାଇଁ
2000 is disputed.
ଫ୍ୟାକ୍ଟମ ଅଫ ଡିପୋଜିଟ୍ ନଥିଲେ ଏତେ ଜିନିଷ ଗୁଡାକ ଆସିନଥାନ୍ତା,
ଆସିନଥାନ୍ତା।
କାରଣ ସେଠି ଏଣ୍ଡୋର୍ସମେଣ୍ଟ ରହୁଛି, ଏଠି ରହୁଛି ଯୋଉ ୱେରେ ପାସ୍ ହଉଛି, ଇଏ ତ କିଏ ହାତରୁ ଡିପୋଜିଟ୍ କରିକି ଇଏ କରିନଥିବ, ତେଣୁ ଡିପୋଜିଟ୍ ହାଜ ବିନ୍ ମେଡ୍, ବଟ୍ just to visualize that why that seal which was is in the original, why it is missing in that, maybe that when the endorsement was made and the xerox was made, at that time the seal was not there, which was made, but it merely because the seal was not there, it cannot be said that the deposit has not been made, because of the fact that the endorsement are there and it has been passed through a different sections, and the register judicial has also endorsed it. So,
and thereafter your lordships have also called for a report.
That
Sir, report clearly likhi dekhi.
Okay, carry forward.
आगे
therefore notice will be given is
it is a place called
so, and moreover, as I've said, this is barred by constructive res judicata also. Just to conclude section 3,
let us be precise that ଆପଣ କହିଲେ ଏଇ ଯୋଉ ଆଭରମେଣ୍ଟ ଆମେ ସ୍ପେସିଫିକ ଆଭରମେଣ୍ଟ ଯୋଉ ଡିପୋଜିଟ ର ଯୋଉ ସେଟା ଆମେ ନେଇଛୁ ପାରାଗ୍ରାଫ 9 ରେ, WS ରେ ପାରାଗ୍ରାଫ 27 ରେ ସେମାନଙ୍କର ସ୍ପେସିଫିକ ଡିନାଏଲ ନାହିଁ ଯେ ଇଏ କରିନାହାନ୍ତି ବୋଲି, ଏବଂ ୟା ଉପରେ ଗୋଟେ ପିଟିସନ ଫାଇଲ ହେଇଛି IN number 19 of 2022, and report was called for, report was furnished, and on that basis on 23/9/2022 an order was passed, এবং except that seal everything is matching along with the endorsement is there. So and you want to also say that
original IN number 20 of 2019 when they filed, then also they have not taken this
plea, nor in this second petition.
That exact and true copy has not been supplied.
This is one of the requirement which was not there, and that stand they could have taken at that point of time. If they have not taken it, then it is constructive.
And they are no way prejudiced, even if that they are no way prejudiced. And no submissions were made by not supplying the seal, we have prejudice or
we were unable to file a defense. That is why it only applies to the election petition again. Election petition they can be prejudiced or they can be misled. ଏଥିରେ ଆଜ୍ଞା ପଇସାଟା ଡିପୋଜିଟ ନ କରିଥିଲେ
ଇଲେକ୍ସନ ପିଟିସନ ଟା ଆପଣ ଫାଇଲ କରିଥାନ୍ତେ, ମନେକର 2-3ଟା ପାରାଗ୍ରାଫ ତାଙ୍କୁ କପିଟା ଯୋଉ ଦିଆ ହେଇଥାନ୍ତା 2-3ଟା ପାରାଗ୍ରାଫ ତା ଦେହରେ ମିସ୍ କରୁଥାନ୍ତେ,
one line ଆଜ୍ଞା ମିସ୍ କରିଥିଲେ my election
example, then that would be a different thing.
Then it is not a true copy of the election.
But ଏଇଟା ହଉଛି ଗୋଟେ
ancillary part.
That is your submission. All right. So this is so far as that issue number 3 is concerned.
3 is concerned. 1, 2, 3, my lords, we have argued.
Or you continue tomorrow?
2 beta kali person.
2 beta. Right. So kali se dita bale taraf na?
Aye.
Okay. Dita bale se order ta ye aji likhibe je in view of the order passed on 9/1/2024, Mr. Vidyadhar Mishra and senior advocate first submitted that he has no more argument to advance. Mr. Milan Kanungo and so on so started the argument on behalf of the election petition. The procedure hard, it is to continue tomorrow, that is on 12/1/2024 at 2 p.m. Okay. So, Mr. Any other matter is there, Mr. Tripathi?
matter.
Bail
But
matter.
yes, Miller. That our state name should be deleted from that.
अच्छा
The confusion.
एटा स्टेट ऑफ ओडिशा लिखा है डिलीट कोन करी
State of Odisha ନାହିଁ ସେଥିରେ।
ସିଏ ତାଙ୍କର ଲେଖିଛନ୍ତି ତାଙ୍କ ପିଟିସନ ଟାରେ ଲେଖିଛନ୍ତି ସ୍ଟେଟ ଅଫ ଓଡିଶା ଆପଣ
Should ଆମେ
ସ୍ଟେଟ ଅଫ ଓଡିଶା ଲେଖିଛନ୍ତି ତ
ହଁ ମାଇ ଲର୍ଡ ତଳ କୋର୍ଟରୁ ସେଇଆ ହେଇକି ଆସିଛି।
तो ସିଏ ତାକୁ ଅନଲେସ୍ ଦିଟ୍ ଇଜ ଆମେଣ୍ଡମେଣ୍ଟ ନ ହେଲା ପର୍ଯ୍ୟନ୍ତ ସେ ସ୍ଟେଟ ଅଫ ଓଡିଶା
କାଲି ରାତି ସାରା ଆମେ ଫାଇଲ ଖୋଜୁଛୁ।
नो नो इट्स ऑल राइट इट्स गुड डन फॉर मी आपको सारे दिन आई तो लिखा है खाली स्टेट ऑफ ओडिशा लिखा so all right so what do you want here is this
ମାଇ ଲର୍ଡ
ଅର୍ଡର ହେଇଗଲା କାଟି
no no item 2 we are going not going to the hearing but going to the that order there is an order item number 1 is a order yes
on the last occasion I have placed those medical documents so my learned friend
the instruction, my lord.
You are granted interim bail
yes my lord
for a period of
2 months my lord.
that period has already expired
No my lord it will be expired on 18th
18th
yes my lord.
now you sought for extension on what ground
My lord medical grounds my
kaharo
lord. My lord for the accused my lord
okay
for the appellant number 3
so Mr. Naik you have obtained
Yes,
instruction
my lord. I have verified and the letter I am supplying, my lord, and have glanced to the second page.
कौन instruction आसिला कौन
It is not required.
तां कॉपी दी जंदी
ମୁଁ ଆଜି ମେଲ ପାଇଲି ଦେଇ ଦଉଛି।
କପି ଟେ ତମନେ ଦେବେନ ସି କେମ ଜାଣିବେ କଣ
ସେଥିରେ ଲେଖୁଛନ୍ତି
ହଁ,
chronic
କୁହନ୍ତୁ।
disease and it can be treated inside the jail.
କୋଉଟା କୋଉଠି ଲେଖିଛନ୍ତି
My lord, second page, the above named patient Brijman Gupta was consulted by me on 23rd 11 2023 for uncontrolled DN1. I prescribed the insulin dose and advised to do UIG in view of the raised urea
and creatine but the patient did not come
for
for follow-up
till now.
action now
However, the disease of the patient is suffering from is a chronic disease and at present no emergency treatment required. The patient can be treated for the disease even staying inside the jail.
ଆପଣ ଡାକ୍ତର ଏଇଆ କହିଲେଣି କଣ ଆପଣ
My lord, I have submission, limited submission. My lord, I am suffering. The appellant number 3.
ସେ କଣ ମନା କରୁଛନ୍ତି କି ଆପଣ ସଫରିଂ ଟା ଆପଣ ଯୋଉ ଏକ୍ସଟେନସନ ମାଗୁଛନ୍ତି ନା ଏକ୍ସଟେନସନ ସେ କହୁଛନ୍ତି ଆପଣଙ୍କୁ ଟ୍ରିଟମେଣ୍ଟ ପ୍ରୋଭାଇଡ ହେଇପାରିବ ଜେଲରେ ରହିକିନି ମଧ୍ୟ ସେ ଟ୍ରିଟମେଣ୍ଟ ହେଇପାରିବ ତେଣୁ ଏଇ ପରିସ୍ଥିତିରେ ଆପଣଙ୍କୁ ଏକ୍ସଟେନସନ କାହିଁ କରାଯିବ
My lord, there is a endorsement, my lord. I am having fissure, my lord. Fissure ଟା 14 ରେ ଟିକେ ଦେଖିବେ
କଣ ଲେଖିଛନ୍ତି
ସେ ଲେଖିଲେ I have verified the document which as original I had given consultation to patient on 23rd 11 2020 for fissure in anus which does not need any emergency intervention oblique surgery.
ହଉ ସେ 31 ଯାଏଁ ତାକୁ ଏକ୍ସଟେଣ୍ଡ କରିଦଉଛି 1 ତାରିଖ ଦିନ ସରେଣ୍ଡର କରିଯାଆନ୍ତୁ ଲେଖନ୍ତୁ
My lord ଆଉ କିଛି ଦିନ ଅଧିକା ଟିକେ
ଜମା ଦବା କଥା ନୁହଁ ଖାଲି IN
My lord ଆଉ ମାସେ ଖାଲି କରିଦିଅନ୍ତୁ
3087 ଏଇ ଟାଇପ ର ରିପୋର୍ଟ ହେଲେ ଏଇ 3087 of transfer is an application for extension of interim bail the London Council for the Central Government Council na Senior Panel Council Mr. Partha Sarathi Naik as per the previous order dated केबे थिला से ऑर्डर टाइटला 4 है कि ना केबे
Yes my lord
4/1/2024 produce the report from the doctors which are taken on record after hearing the London Council for the parties and going through the reports furnished, I'm inclined to extend the interim bail order which is supposed to expire 18th of January 2024 till 31st of January 2024. The petitioner shall surrender before the London Trial Court on 1st February 2024. Matter will be listed in the week commencing from 12th of February 2024. The London Council for the appellant shall produce the surrender certificate on that day. Yes, এটা নিয়ে
Grateful.
आई এটাও ডিসপোজ অফ করে দেবে হলো বাকি থাও আর নেই
Item number 3, your lord.